Yeah, my lord's kind leave to mention item number 66 is a tender matter, my lord. My technical bid has been rejected, my lord. And my lord, the financial bid is about to be opened, my lord. If this matter can be fixed, my lord, any of the day, my lord, of your lordships, my lord, in the next week.
If I go on upgrading tender matters, other matters cannot be taken up.
My
Try
lord,
to understand.
my lord, any day, my lord. Next
Any
week,
day means
my lord,
please wait.
my lord, the financial bid will be open, my lord, then tender will be finalized, my lord.
Nothing can
My
be
lord,
done. I'm
Kindly, my
sorry.
lord,
my lord, I'm seeking.
kindly, my lord, kindly upgrade this.
No, sorry. Yes.
My lord, I'm seeking leave, my lord, to move a matter urgently, my lord, before your lordship. My lord, of your lordship's determination, my lord, on Tuesday, my lord, subject to your lordship's convenience. My lord, the petitioner before your lordship, my lord, is the Shongadipati of a society known as the All India Mutua Mahashangha, my lord. The petitioner himself, my lord, is a member of the parliament, my lord, and the union minister for the state, my lord, from the party in opposition. My lord, this All India Mutua Mahashangha, my lord, has been there for ages, my lord, and since 1953,
What
my
do
lord,
you want?
my lord, there is a mela, my lord, known as the Mutua Dharma Mahamela, which will, my lord, start from the 20th of March, my lord, 2025. My lord, last year also, my lord, with regard to this mela, we had sought for permission because, my lord, DM's
From
permission is
DM.
DM, district magistrate.
Yes.
My lord, DM's permission so sought for, my lord, on the last occasion also, my lord, they were not giving permissions. My lord, this honorable court had to intervene, my lord. My lord, since obviously, my lord, because of his political backing, my lord, which is why these permissions are not being given. My lord, I'm beseeching you before your lordship, my lord, if this matter could be taken up on Tuesday, my lord, since, my lord, it's a similar
Did the
issue.
other authorities give you permission?
Everyone, my lord, everyone else's permission, my lord, is dependent on the DM's permission. So fire, my lord, electricity, everything will only happen, my lord, once the DM gives permission, which is why, my lord, I want to move it before your lordship, my lord, on Tuesday. My lord, otherwise, others will not give me permission. And this has been holding
When
from
is the mela
1953,
going to be held?
20th of March, 2025, my lord. And, my lord, we need at least, my lord, a week's time, which is why, my lord, I was beseeching Tuesday, my lord. My lord,
Very well, Tuesday.
deeply grateful, my lord.
My lord, I beg to mention a matter, my lord.
Ensure service.
Yes, my lord. Yes.
My lord, I beg to mention a matter, my lord. Upon service, I am approaching your lordship, my lord. I think
For what?
my lord, for upgradation or fixing, my lord. My lord,
Please.
kindly here, my lord, kindly allows me to address your lordship, my lord. Kindly not take this opportunity from us, my lord. We as it is
It
get
cannot be
limited
done.
opportunity.
It cannot be done,
Kindly
sir.
fix me on, my lord.
You understand the pressure of the bench.
My lord, the
If you
petitioner
go
is,
on
my
with
lord,
this, it cannot be done. Please
my
wait.
lord, the petitioner is
And
agriculture.
I have fixed up a day for upgradations. Come on
My
that
lord,
day, I'll
this is
upgrade
running
it.
on the daily list, my lord, because if it was not in the monthly list, my lord, I couldn't upgrade it at the
Yes.
question, my lord. Now, the petitioner is a matter agriculture, my lord. His water connection has been taken out, my lord. He's been disconnected. If
By
my lord
whom?
doesn't hear it, my lord, the local Gram Panchayat, my lord.
Go before the panchayat determination. Why are you here?
No, my lord, it is under the dispute, my lord. We want
Why?
to do it before your lordship, my lord.
Why?
My lord has a determination.
How can it be? If the panchayat members have done something illegal, you have to go before the panchayat
There are
bench.
multiple authorities involved, my lord. Panchayat is one of the concerned authorities.
Who are the other authorities?
My lord, it is a committee, my lord, formed by the panchayat itself.
Yeah, obviously it will go
There is a
before the
DM,
panchayat
my
bench.
lord, there is a police officer.
I can release the matter so that you can immediately go instead of waiting in the list.
I believe, my lord's determination is the appropriate determination.
How can it be? The matter will be taken up. It will be it will be released. It will consume a lot of time.
My lord, it is for restoration of water connection, my lord, to the paddy fields, my lord. If my lord doesn't hear it, my lord, we will not be able to cultivate our land.
Why? There are other determinations. You can go over there.
My lord, again, my lord, I will beseech your lordship, my lord, does not take the opportunity for us to address your lordship, my lord. As it is, we
You
get
are
very
always welcome, sir. But the matter has to be within the determination of the court.
my lord, if my lord so
I
advises,
let it remain. Yes.
My lord, kindly leave to mention a my lord, a repetition that has been filed for quashing of an FIR. My lord, this is a political witch hunt that's going on.
Whatever, it is
My lord,
there in the list.
64 of your lordship's list. My lord, but
Please wait. Yes.
My lord, may I be permitted to mention, though it is in the monthly list, running in the monthly list.
You
My
want
lord, just-
upgradation?
Yes, my lord.
Please
My
do
lord,
not mention.
kindly hear for 1 minute.
I will
My lord,
not.
kindly
Because
hear.
if I hear one, I have to hear the others
No,
also.
kindly hear. Then,
There
my lord,
cannot be
if
no-
my lord desire to reject, then reject. My lord, the main problem is this: the civil suit and the writ petition is pending. We have filed the writ petition, and the writ petition is pending. And in spite of this writ petition pending, the subdivisional magistrate, my lord, passed an order for demolition. Though we have got the temporary injunction, my lord. The demolition order passed on 25th of February, my lord.
You have the civil court's order? Go. Yes.
But, my lord, the subdivisional magistrate had passed the order.
Item 620 praying for release because relating to PWD unauthorized construction.
620?
620.
620 released.
May I permitted your lordship? Public for restoration, your lordship.
I'm grateful.
Restoration, your lordship. Several times you tried
Several times where you tried?
Monday were time, but several application was submitted before also rejected.
All applications were accepted, not a single refused. I'm sorry, sir.
I'm trying.
Sorry, yes.
Lordship, there is a company, my lord, under CRP process by the direction of learned NCLT Kolkata bench. My lord, company got one resolution plan that has not
What
been
you are-
succeed. My lord, being ED has been attached the property. My lord,
Yes.
without lifting of property, attached property, my lord, need direction of the lordship because CRP
Where
process
is the matter?
expired on this March. My lord.
Where is the matter?
My lord, lordship, matter is item number not in I on earlier occasion, my lord, I mentioned the matter and for inclusion, my lord. That has been I get to know that some requisition has been sent to the mandamus.
Then wait, please wait. Yes.
I have one request and prayer. Although on that day I could not be remain present. Lord, your lordships have fixed up one of my matters, that Mandarbani matters on 17 March. Your lordships have fixed. Lord, I have real difficulties on that day. Would your
That
lordships
day,
kindly
let
take
it.
up- just to, Lord, I will not be here. Either your lordships takes up around, Lord, since the house is going on 21st, I will come and I will do the matter.
The matter will remain in the list.
Hmm.
Tell any of your friends to mention.
My lord. My lord,
Anybody?
I'll mention just I am intimate.
All right.
Give like.
Yes.
I mentioned this matter on 3rd March for upgradation, Lordship. Lordship, the urgency is that they are threatening us to.
You have mentioned
Lordship, yes, Lordship.
it has been allowed.
Yes, Lordship.
Then please wait.
Lordship, they are threatening to invoke the bank guarantee, Lordship.
Yes. Who is threatening?
Lordship,
You don't know. Get
Lordship,
ready.
the-
Lordship, kindly leave to
Yes.
mention a matter arising out of determination of Justice Sengupta, my lord. Public Premises Act, my lord.
Do I have the determination?
Yes.
I am not aware.
The
My
determination-
officers are also not aware.
Well,
I do not know.
well, we had seen the notification, my lord.
I have not got it as of now. Yes.
My lord, 2 writ petitions have been wrongly filed before Justice Aniruddha Roy. So kindly mentioning to include the matter before this court.
Is it there in the list?
No, no, my lord. Order passed dated 14/11/24.
When did you file it?
I have no knowledge about that.
You have to know it. Otherwise, how can matter be included? Yes.
My petitioner is facing an order of demolition passed by the order of NGT, but we have records to show that when the NGT's order is erroneous on the facts as well as on the law, my lord. But this matter is similar to that matter that mentioned by Mr. Bandopadhyay. These properties in Digha, my lord. We have complied with the CRZ notification, but none of the construction of ours violate the CRZ notification. But even then, my lord, our property has been, my lord, demolished. My lord, there's an order for demolition, and we are facing this demolition, my lord, this threat of demolition.
Yes.
If your lordship kindly accommodate us, my lord, any day, my lord, any day, my lord.
The other matter just now it was mentioned is fixed on the 17th.
We can come on 17th, my lord.
Yes, give the number.
Circulate the notice, my lord.
Same day it will appear, and then there is a request for adjournment also. We'll take up all the matters together.
Lordship, may I have your
Yes.
lordship kindly leave to move one matter on urgent basis. The matter relates to a tender under the ICDS scheme of Murshidabad. Now, my lord, the private respondent has been appointed, my lord, by virtue of, my lord, a false, my lord, bid. My lord,
That means the tender is over. The
tender was
bids are
opened on
open.
5th of March, my lord. Today is, my lord, 7th. The
Yes.
NIT specifically mentions that absurd rate quoted by any bidder will be outright rejected. And the person who has been approved, my lord, has quoted 96 paisa per metric ton, my lord, which is far, my lord, from the, my lord, prevailing market rate.
Yes.
Petitioner, my lord, has participated in the tender, my lord, has quoted, my lord, a relevant, my lord, market rate, my lord, kindly takes up this matter on Monday or, my lord, Tuesday, because the work order has not yet been issued, my lord. If the work order is issued, my lord, the matter will become, my lord, infractious, my lord. Kindly, my lord, takes up the matter on Monday or, my lord, Tuesday.
The chance of interference by the court is extremely limited.
My lord, the NIT specifically says, my lord, that the absurd rate, now, my lord, 96 paisa is, my lord, absolutely, my lord, absurd per quintal, my lord.
It may be absurd for you, for the authority possibly it was not, and that
My lord,
is
my
the
lord,
reason they have
average, my lord,
accepted it.
The average market rate, the last year was 72. I have quoted, my lord, 72 itself.
Whatever.
Kindly, my lord,
Want it?
kindly give me a chance, my lord, to demonstrate, my lord, kindly, my lord.
Tuesday come.
My lord,
Serve notice.
Now, lordship, kindly leave to mention, my lord, my technical bid has been, my lord, rejected. My lord, the My financial biz is going to be open, my lord, on 17th of this month, my lord. My lord, let it be taken up, my lord, on the grounds, my lord, the technical bit rejected on the grounds. There are some discrepancies in my tender form. No, my lord, that's the only reasons. That's why it rejected, my lord.
Then what can be done?
My lord, that is the provisions therein in the tender document that I can have the right to rectify the discrepancies. So that was not done. But only this, my lord, this will be, my lord, the financial biz is going to be open, my lord, the 17th.
Wednesday 12th, come,
My lord, may I be
serve notice.
Fine.
this matter on urgent basis on Tuesday? Well, the urgency is that the candidates have passed MBBS courses. Now they are the residents of Rajasthan and they have completed their internship from the West Bengal under the West Bengal Medical Council.
Education matter.
Not really, because they are going to participate in a selection process to be done by the Rajasthan Medical Council.
But then connecting to education, isn't it? How can this be taken up by
Connected to
the
education, my lord,
residuary
because
bench?
these are not now students. They have pursued, they have completed their MBBS degrees. The only thing remains is the the registration certificate to be obtained from West Bengal Medical Council and a no objection certificate. Now the difficulty is this: there is no registrar who is to issue that. But there is a registrar of West Bengal Medical Council.
There is no registrar.
At this present, there is no
Somebody
registrar.
should be
There is an
officiating.
assistant registrar.
Yes.
There is an assistant registrar. We have made several representations, emails, letters. My lord, he is empowered to issue that, but he is not issuing that. We are only on that aspect.
All right, Wednesday it will appear, serve notice.
Can it be on Tuesday? If
Why? One day, what?
difficulties of by 2nd of April, 2nd of April, they had to participate in the process, education process.
Tuesday is only 11th.
My lord, I come back on Wednesday.
Tuesday, Wednesday is 12th.
My lord, Wednesday, I come back on
Wednesday?
My lord,
All right.
stop at giving so-
Yes, urgent motion, it will be there.
Notice, my lord. It is for inclusion for the application. Lordship on the.
Appellate side? Appellate side?
Yes.
But then inclusions I will not take up today.
My lord, the only difficulty is that since my lord on 27 January, your lordship heard this matter. And since the writ petition was not served, your lordship needs to dismiss as not pressed. Since there is no instruction from erstwhile advocate, he was not present. He sent his junior. I don't know what he made submission before your lordship.
So you want recalling of the order?
Yes, my lord, because there is a pending in DRT and only.
I do not know. Whatever the submission was made, the court relies upon the submissions of the learned advocates. The court doesn't have any fancy in dismissing these petitions.
The application has not pressed.
That is what the submission was, possibly.
I don't know, but
You
there
have
is
to
no
check up.
instruction from the client, petition of to place before.
You have filed it in the department, it will appear. No mentioning, yes.
May I, DM Alipur has.
What you want, tell me please.
My lord, I want this matter to be taken up urgently.
Urgent, where is the matter?
The matter is here, my lord, it's filed yesterday.
Yesterday?
Yeah, it's an order by the DM.
Yes.
South Chowbis Pargana against a property which is situated in Beleghat.
Right.
The contention of the petitioner is that it is wholly without jurisdiction, my lord.
Why without jurisdiction? Under which law was the order passed?
Under section 14, my lord. It's a order by section 14, section 14 order SURFACE Act.
DM has passed.
Yes.
Where is the problem?
The problem is that the contention of the petitioner is that DM has passed the order without jurisdiction, my lord.
Why without jurisdiction? DM does not have the power to pass order under section 14 SURFACE?
Yes, my lord, but
then?
But it's Beleghata. The property is situated in Beleghata, my lord.
Yes.
And the DM is South Chowbis Pargana.
South Chowbis Pargana, Beleghata falls within that jurisdiction. Under whose jurisdiction does it fall? Under which jurisdiction does Beleghata fall? If the order is without jurisdiction, section 17 of the SURFACE is there. Immediately go and approach the competent forum. All right. And in case your writ petition is here, it will be taken up in usual course.
Yes.
All right. In usual course. Please wait.
Well,
Yes.
may I permit to mention this matter is relating to 2021 election non-payment of admitted due.
When did you file it?
That is in the Delhi list.
It is there in the daily list. Matters have been fixed. Please wait, see what happens, and thereafter similar orders can be passed in your case. Nothing to mention. Call the list.
Well, I'm for the petitioner, my lord.
Yes.
There are two, my lord.
This point also kindly declares is that matter.
I know.
Where my lord,
I've
Mr.
told
Ghosh has on the
Mr. Dev was very vociferous.
Vociferous.
Submission. for getting the order application dismissal. It is up to your lordship because I have come for presentation of the contempt, my lord, the jurisdiction.
Yes.
If your lordship satisfied that,
Yes.
of course, my lord, that it is not necessary.
Let me see the
Logically,
compliance.
that, my lord, that two orders were passed by your lordship.
Yes.
It's a common orders in both the cases. Therefore, my lordship takes it up. CC number 15. CC
Okay.
number 15.
CC 15
I have the 14.
No, the orders, I have
Acha,
I
orders
will
same,
present
orders
the
same.
orders.
Very good, orders same.
I'm not going
No,
to
no,
other.
orders are same, orders are same.
Your lordship
Yes.
kindly sees my lord's order, my lord, 22nd May and 21st May. Two orders, one at page my lord 170 and another page, another my lord order is 172. Because of the other petitions have been my lord annexed.
Why? There is no requirement of annexing unnecessary photocopies and making things voluminous.
So it might be necessary in certain cases, my lord. That is the reason, my lord. I have
Yes, 21st of May.
170, your lordship can see, my lord, that this is, my lord, this is an undertaking of the petitioner
Hmm.
to provide the same frontage as Mohammed Nasir is enjoying currently, and has been recorded in the agreement intended between the parties. This is one, my lord. And finally, your lordship passed an order when my lord shifting to take place. Next order at page 22nd May 2024. That order speaks of that third paragraph, 173, your lordship can leave at this third paragraph. Upon completion of the construction work of the proposed structure, Arup Kumar Shah will provide a permanent accommodation to Mohammed Nasir as per the agreement entered between the parties. That the agreement, my lord, shows, if your lordship kindly come to the agreement part, that is at page, my lord, 47. Later, your lordship kindly come to page 52. This is the schedule of the property existing position of the tenant.
Yes.
That the piece and person one shop room measuring about 150 square feet be the same, a little or more or less, length 13 feet, breadth 11.8. This is the area to be provided. This is in the existing position. And what is to be given? Illogically, schedule of the property. Next schedule, newly possession of the tenant in the proposed newly building. Then it is also said the same length and breadth to be provided. Now, my lord, they was making, and this is your lordship's direction that this length and breadth to be maintained while permanent accommodation to be given. Now, while making construction, he was, my lord, covering the entire area, construction area. That is, I could not follow. That is the reason, prima facie, I submitted to your lordship that regarding the frontage. This is one aspect of the matter with regard to the order of 21st May regarding the frontage. Then your lordship on that occasion, on the contempt application, 17th February 2025, your lordship directed that frontage primarily is an issue. Therefore, engineers to take steps to measure the, to ascertain the proper facts and to submit a report. Now, he has submitted a report. My client has also prepared a report. Your lordship can see the report. I am not dispute because on facts, my lord, there cannot be any dispute with regard to that. This is it. That's it. Take it. Yellow she kindly come to.
Are you having a copy of this report of inspection? Give.
I will give you.
Otherwise, how will he follow?
No, he also did not. I understand he on the last occasion he had given a hand report to lordship, my lord.
Without a copy to you?
Without copy to me.
How can that be? Where is his copy? Yes, what is here?
Logically, my second page. Logically, see the second page. I'm not troubling your lordship because the initial direction, then date was changed on the request of my learned friend. I am told he was he reported
Yes,
to
I
your lordship
mentioned
that
the matter.
no, that I'm not going an issue. That fact has been recorded. Logically, the second page from the last paragraph, in the circumstances above, I went to the site at about 5 p.m. on 25th February 2025. When Mohammed Nasir and his son who were present, it has been mentioned. It was found and observed that the front side of the shop room is at the straight corner of the building. However, next page, the shop room had been kept closed by shutter. It was open for few minutes just to permit the engineers of the parties to take the measurement of the straight frontage of the shop just at the shutter position. On measurement, it was found that the frontage of the shop room was about 12.1 feet. I'm not disputing. My landlord also said
No,
so.
I said it is 12 and half, 12.5.
All right.
12.1
This
feet,
was measured before
just
you.
which
All right,
is
then.
equivalent to the breadth of the shutter. Immediately thereafter, the shutter was put down, preventing me to take the measurement of length and breadth of the entire shop room as requested by Muhammad Nasir and his learned advocate on the plea that the Honorable Court only asked to take the measurement of the frontage of the shop, which was the issue raised by the Muhammad Nasir. Although it was not permitted to take the measurement of the length and breadth of the entire shop room from inside, I have drawn up a plan of the shop on my visual observation from outside. The shop plan as prepared with the measurement indicates not only the location but also the gradual reduction of the breadth of the shop from 12.8 to 8 feet.
12.8 কোথায় পাচ্ছি?
From 11 to
12.8, 12.1
11 to
8 feet. Gradual reduction when I go inside the room. In fact, the frontage of the shop room is in slanting position because it is in straight corner. Therefore, in slanting position, always the length, the breadth would be much higher. What my answer is 12.1. If it is makes straight, then it will be 8. If it makes straight corner, and when the position of the shop goes behind the inside from the slanting position to straight parallel position, it becomes 8 feet. The breadth of the frontage of the shop may be technically said as about 12.1 feet, or my answer 12.5, whatever it may be.
12 and half, 3.
Only because of his slanting position. But in reality or in fact, it is 8 feet. It is thus clear that what was proposed to be provided in respect to the shop room, having its length and breadth measuring about 13 feet by 11 feet, it is found missing as observed on inspection of the erected shop to the.
You must be having a plan pursuant to which you made the construction, and the shop is shown.
Everything has been done.
What is the measurement in the plan in respect of this shop room?
Not I'll show you, Rossi.
And another issue is there, my lord. I have seen the plan, sanction plan, that the position of it might not be in the same position as in the sanction plan, because he has to surrender about 2 feet and land of his premises to the Kolkata Ministry gifted. That is in the plan. That was directed to be made before taking up the works. And I find the evaluationally sees my plan, the sketch plan that annexed here. The drawn up plan.
Yes.
The drawn up plan shows, my lord, that slanting position. No, in the report.
Oh, in the report.
In the report.
Oh.
But the slanting position, of course, 12.1, I take it my license condition, 12.5, whatever it may be. Then when it goes down to the premises, then it is slightly started reducing 9.5, then 8.10, then 8.5. This way, this changing has taken place. But it cannot be said.
So
11
this
point
side portion has been gifted.
Side portion has been gifted. Now you logically find 672 has been mentioned here. Logically find 672. 672 means 2 feet 3/4 inches. Now this is the mandatory open space to be provided because of the reasons provided. The corporation has allowed him to surrender that the portion strip of land as per sanction plan. This portion is to be gifted. That portion I do not find. My client say, my lord, that has been not been found, has been gifted because this property line stands from that 672. If that is gifted now, then
you
the
get
shop
some
position will
space.
be shifted from there, from this position.
It will go behind.
And it may be considered that this position of the shop room is in not in proper position of the plan. They need to be considered as a violation of the sanction plan.
Then you can make further complaint before the corporation and
No, no,
proceed.
complaint, my lord, that to be examined because the corporation has given, therefore, my lord, report to be given whether in the same position. Because 672, if it is, my lord, not in the same position, then I cannot take it, right? Even if I take it, you also can consider that the construction which has been made, ultimately 152 square feet is there, but length and breadth is not the same. As my lord, he
Square feet is
said.
there and the frontage has also increased.
No, no.
Lordship kindly takes, Lordship is with this plan that he has submitted. Now my lord kindly takes up the affidavit that I had filed. Lordship kindly considers page 9. Page 9, my lord.
It can't be said the length
But
and
the
breadth are
same-
same.
But it's more than 152. I am told it may be 153, but not less than 152. And the frontage has increased. Lordship kindly sees my affidavit.
No, that you've told me on the last
Yes,
petition.
and he has also concurred on that. This is 3.
No, no, I do not dispute against a slanting position. I'm not
670.
disputing because engineers cannot dispute about that the measurement.
Yes, now, my
Slanting
lord-
position, all right. He could not allow me to make the measurement of inside. When
No,
it
because
goes
on
inside
that
the
date, may
premises,
I now make my
then
submission?
it becomes well automatically reduction.
May I make
Therefore,
my
he
submission?
cannot
But on
provide
the
me
first
well,
date when this
11
was
point,
taken up by your lordship in presence of both the parties, he said
11.8.
the
well,
only
which
issue
he
is
cannot give well, all along.
with the frontage. That
No,
was
no,
his
that
submission.
I did because of the. No, I'm submitting.
Is anybody there for the, is the corporation a party?
The corporation has not been independent. I'll be requesting to Lordship to give a report because corporation was not the right. There was an issue. Now the issue has come. My lord, the corporation has to give some report to your Lordship, my lord.
But that will be later on. Lordship will kindly consider the first order passed by your lordship. And this has not been placed before
And
lordship.
do you think that it can be done in the contempt jurisdiction?
Contribution because he has
But
to
one
give
thing-
me. He has to give me the your Lordship directions.
I've
As
given him
per the
whatever-
agreement.
Whatever is the
As per the
I've given him.
agreement, he
My
has
lord
to
kindly
give.
take page
If it is
167.
my lord, I take it.
Page 167. Page, very good. Lordship kindly takes up my affidavit
Report.
at page 9.
Yes. Give a copy to,
No, no,
have you
I
given?
have given it.
Page 9.
Page 9. This is my handwritten, no, this is my field
Handwritten
notes.
note.
On that day I was present there. This is my field note. The last line, my lord, 3.670 meter.
3.670.
And lordship kindly finds the frontage, the same.
Hmm.
Their engineer also concurs with my finding. My lord, 3670, that may be centimeter. So my lord, the frontage is there. 152 square feet is what the room should be. It may be 153, but not less than 152. So my lord, there is no contempt at all. And lordship will kindly consider page 167. The first order passed by lordship 22nd April 2024.
Yes.
That may be page 168 in 15. The first order.
Yes.
First product,
হ্যাঁ,
there's the
আরে
undertaking.
বাবা দাঁড়ান না।
আমার discuss
না না
করতে
আপনি
হবে।
যদি
One minute, 1 minute. Yes.
Lordship kindly sees page 160, yes,
Yes.
first order, 22nd April 2024.
Yes.
The petitioner, etc., Mohammed Nasir has filed a petition challenging. Lordship comes to the next page,
Yes.
the third paragraph. The parties are directed to take steps for measuring the area which will be allotted to Mohammed Nasir. Length and breadth of the present shop room and the proposed shop room that will be handed over to Mohammed Nasir, and the location where the proposed shop room will be allotted shall be identified. It will be open for the parties to make video recording at the time when the measurement will be taken. The parties may take help of their engineers at that time. Now, my lord will kindly consider these two communications. These, my lord, they are suppressed intentionally. Lordship kindly sees this. This is not there in the contempt petition. They are suppressed this. This is, my lord, I had written to them on 23rd April. Lordship kindly finds they have received it. What I have written, my lord, under instructions and on behalf of my clients, I am to state you that my client will be present at the subject premises being so and so with an LBS engineer on 27th April 2024 at 11 a.m. in compliance with the order passed by order dated 22nd April 2024 passed by the Honorable Justice Amrita Sinha in the above matters. You are requested to inform your client accordingly so that measurement work can be executed in compliance with the solemn order dated 22nd April 2024. Lordship kindly takes up the next page. They reply. I am in receipt of your letter date 23rd April 2024 regarding measurement of the subject shop room at so-and-so on Saturday 27th April 2024 at 11 a.m. Please note my client has engaged one Sumon Mondol, civil engineer and licensed building surveyor for taking measurement of the length and breadth of the present shop room, and the length and breadth of the proposed shop room will be handed over to my said client in terms with the direction of the Honorable Court dated 22nd April 2024 passed by Honorable Justice Amrita Sinha. You have to read petition. Well, this was done. My engineer was that, his engineer was that. Everything was explained to them. Both the engineers measured. Then they came to the agreement. After that, they were satisfied that yes, after that, I had to relocate them into a temporary position. But I had one sanitary one shop room there. I had located there temporarily. Thereafter, I have made construction. That shop room is completely ready. He can take possession any day. Now, my lord, I have already shown your lordship the frontage. It's more than 12.5. The area of the shop room, my lord, 150 square feet. So, my lord, or more than 150 square feet, maybe 153 even. So, my lord, where is the content? I was just putting my question to this myself, my lord. Where is the content, my lord? And on the first date, Mr. Ghosh, my lord, I said that the frontage, lordship kindly recollects, even my lord, I have that videography of that on that date, my lord, on 17th March. My lord, I said that he said 11.8 is the issue. I said it may be more than 11.8. Your lordship recorded your lordship's order on 17th February. Upon hearing submissions made on behalf of both the parties, the petitioner, it appears that Mohammad Nasir has an issue with regard to the frontage of the shop room that has been provided to him. According to Mohammad Nasir, the frontage has reduced. According to the contemnants, the frontage has increased. But on that day, lordship kindly recollects, I have stated that it will be more than 12. In fact, it is now 12.5 or 12.6.
Very well. I see prima facie there is no contempt.
Obligement.
I'll give you liberty. You take
No,
up
usually
this
it's
and-
one
And lordship will
Again,
record,
one-
lordship
You know,
will- no, no, the content, my-
where
how
the
one will take?
situation of the
No, no, it is between your
just
lordship
a
and
minute.
your lordship and the
You
content.
can
Your
single
lordship
one
is satisfied.
document.
No,
You
my
can
lord, this
single
way-
one.
this way cannot be.
You can
content.
single this here.
Well, I have other things to show. If he continues in this way, I have other things to
Yeah,
show.
lordship, well,
How much
single
he's
where
using
the-
this
one
content
minute,
petition
one
as a
minute,
leverage, my
one
lord, to
minute.
exploit my client. This is
One
being done.
minute, your Honor.
This is being done. Grateful to your lordship.
Usually get it ascertained whether the in the same position.
The report of inspection filed by the engineers of the petitioner is taken on record. Stop. Prima facie, upon hearing the parties, it appears that the order of the court has been substantially complied
Much
with.
obliged.
Stop. The petitioner alleges that the contemner has not made the construction in accordance with the plan sanctioned by the Kolkata Municipal Corporation.
Lordship kindly records. I dispute.
Stop. The aforesaid allegation stands disputed by the learned advocate representing the
Another-
alleged
No, no,
point-
that
Another point be recorded, Another point be recorded. Illogically sees, my lord, that the sanction, the SOB order which has been obtained regarding the compliance of the order, there shows the curtailment of the position of the shop room. That is the reason I am showing to you plan, your lordship. Because I came to your lordship, my lord. for
The
consideration
I will-
of the order.
petitioner also alleges that
It's the SOB.
there has been curtailment in the position of the shop room of the petitioner.
But again, I dispute
Paragraph.
that, and I say, my lord, everything
The
has been
same
done.
has again been disputed
In this
by the
according to
learned
the sanction
advocate
plan.
representing the contemner.
And
Stop.
but the construction has been made
According to
according to
the
the sanction plan.
contemner, the construction has been made in accordance with the plan sanction.
My lord,
Paragraph.
and also in accordance with
As
the lordship's order and in
Prima
compliance with the
facie,
lordship's
the
order.
court is satisfied that there has not been any willful, deliberate,
Grateful
or
to your lordship.
intentional violation of the court's order.
Deeply obliged.
Accordingly, the court is not inclined to proceed with the contempt application any further. Stop. It will be open for the petitioner to approach the competent forum for further relief, if so advised.
But only one thing, my lord, the shop room is ready. Lordship kindly, no, lordship
Petition
kindly,
is pending. I
lordship,
can approach because writ petition.
no, lordship will kindly record that, my lord, the shop room is ready.
Writ petition is pending.
Yes, my lord.
Then why are
Then
you
yes.
just taking the con?
Interlocutory order, they have to provide me. That is the reason.
No,
I
no,
will
that is,
approach this.
my lord, only one thing, my lord, lordship kindly
It
record.
has been brought to the notice of the court that a writ petition is already pending before the appropriate court. Stop. It will be open for the petitioner to raise all issues before the said
No, my lord,
forum.
all issues you cannot raise now. My lord, no, lordship,
Whatever the
my lord, no,
connected,
lordship
all
kindly not,
connected issues.
my lord, kindly not record that, my lord. Lordship will kindly not record that.
Open.
Writ petition
No, no,
to be
that,
considered.
and lordship
Go
will,
and,
yes, and lordship will kindly
Challenge
record
To be
that
considered.
the shop room is ready. He may take
Writ
possession.
petition
Lordship kindly
consider.
records that. My lord, lordship kindly records that.
Writ
He
petition-
is not,
writ petition to be
he is not
considered.
taking possession.
No,
Writ petition to be considered.
because
You
he
are
has
not
to,
taking
no,
possession.
he has to hand over me.
It is not ready at as yet.
He is 100% ready.
No, no.
My lord, he
He
has
can
to
say.
hand over me the temporary shop, and lordship kindly
It is
records that.
decided.
Lordship kindly records that.
Disposed. Both the matters
Well,
disposed.
lordship kindly records that the shop room is ready, my lord. Lordship kindly records that. At
I-
least
I'm
let
sure
it,
that it's not ready.
let it be my submission
It's
recorded
not
by
ready.
lordship.
Writ petition
No,
to
no,
be
my lord is
decided.
recording his submission. So my lord will
I'm
kindly
not-
record.
I'm not-
Lordship will,
Writ
lordship will,
petition to be decided.
no, that let it be decided. Lordship will kindly record the submission. Grateful to lordship.
This is my application.
that my grievance was really with regard to the respondent number 1 bank, my lord, making over information to CIBIL, TransUnion CIBIL, which is the respondent number 3, regarding a purported loan account, where I am shown wrongly as a guarantor or a co-applicant. I have no connection with the principal applicant. After I filed the writ application, bank wrote me an email saying that we have made the necessary rectifications and communicated it to all the credit information bureaus. On the last occasion, your lordship had directed the CIBIL to come back with instructions whether such communication had been made, and if so, whether the necessary rectification has been done. Because this
That's been
email
done?
was of
Yes.
this email was of 15th of February, where ICICI said within 9 days it will be reflected in my CIBIL score. We are, my lord, already more than 20 days thereafter.
I am for the respondent 1, my lord.
Which
Bank.
respondent?
Bank, my lord.
Yes.
Respondent number 3, my lord.
Respondent number 3 is civil. If you
One is the bank.
Respondent number 1. Sorry. Yes, madam. We have sent them a mail, and we have intimated CIBIL, and CIBIL has replied me right email dated 16 February, my lord. They says that they cannot disputed account. Please note that disputed account cannot be relinked as the same is reported to the contact number so, and simultaneously in same contact number is reported to the complainant through account dated so by another member institution.
What does this mean?
Means by that another bank or any financial institution has also reported before the CIBIL against my lord the petitioner. That is we have, my lord.
Otherwise, my lord, what I have been informed by CIBIL, my lord, that a particular format is followed in which the information is to be provided. ICICI Bank only has written an email to get it dealing without following that particular format where the other requisite informations are required to be provided. CIBIL asks for those to follow that format, which has yet not been done by the bank. Moreover, my lord, on this today morning, there is a further email received by the bank in which the instructions are a little bit contradictory to the earlier email. So I'm praying for 2 weeks' time so that the CIBIL can obtain clarity on this matter, because their instructions are also not clear and they have not followed the procedure. There is a process OLM format in which the bank is aware, because other information in respect of other accounts are provided by the bank in OLM format. This is the usual format which is followed, which the bank has not done, merely written an email that dealing this name from the account.
This is the mail we have
May I
received.
hand over a copy of the email written by ICICI? Your lordship kindly has a look at this.
Date? What is the date?
This is 15th of February, written by ICICI to the petitioner.
Right.
Saying that we have informed, obtain necessary approvals and send the request to all bureaus for removal of your name as co-applicant in the personal loan. And my lord, so far as the 16th February email is concerned, my lord, my mobile number may be linked with with various loan accounts. I am only concerned with this one particular account. Complaints with regard to other loan accounts is not my concern, not the subject matter of this writ application. Let them dealing so far as this loan account is concerned.
This is the reply you have
I
got
don't
from
understand.
CIBIL, my
And
lord.
so far as the formal requisition of ICICI is concerned, let that be done then within a prescribed.
No, they have not
From
intimated
what I
this
understand,
whatever.
there is no formal
What
request.
is the reply you have received from the CIBIL, my
Provide
lord?
the information in the particular format in which it's done, my lord, so that CIBIL can also process.
Well, this is the original email that was sent
Please
after
come.
the writ application. 15th of April. May I just send it? The
The
record
petitioner's prayer for removing the name. You want removing or upgrading your name?
Delinking of my name to that particular loan account, because that affects my CIBIL score.
The petitioner's prayer for delinking his name from the loan account being LPCAL. Last 4 digits is 5987.
Yes.
Is pending consideration at the end of the civil authority. Stop. Paragraph. Learned counsel representing civil submits that The bank did not forward the necessary information in the prescribed format, for which the CIBIL could not take action in response thereto. Stop paragraph. The respondents are directed to proceed to consider the prayer of the petitioner. The writ petition stands adjourned till you want 2 weeks' time.
Yes, my lord.
Acha, 20,
Can you directly be passed upon ICC Bank to follow the process, my lord?
26.
That OLM seat, which I have been informed that the information is required.
They
to be
have-
I don't know, the bank doesn't say anything.
This is my instruction, my
My
lord.
lord, they have
Wha-
said the
whatever
civil
the-
has replied us that this is the reason we cannot dealing this matter, dealing is the
May I
account,
have
my
a
lord.
copy of
Yes.
that?
Yes, yes, certainly give a copy.
Okay.
Next.
26.
Lordship, I'm appearing for respondent number 1. I'm led by Mr. Abhimanyu Shandelia.
Ma'am.
Lordship, as per the last instruction, the affidavit of opposition was to be filed. I'm filing it today before Lordship.
And maybe also file the reply.
Yes.
But I'm filing the affidavit.
This relates to a fire and special peril policy. The petitioner is engaged in the business of, my lord, production of cotton-related products. Lord, we have got about 4 factories.
Lordship, may I be permitted to say?
Where is your plant?
My lord, my plant is in a village called Murugacha,
Yes.
under the jurisdiction of PS Ghola, Ghola, Ghola.
District Nodia?
No, that is the issue. Now, my lord, the interesting part is there is no dispute of the fact that there was a fire. There is no dispute of the fact that there was damage. This is a special peril policy, fire and special peril policy. So they appoint a surveyor. Surveyor goes to my factory at Murugacha in Ghola, which is in 24 Parganas North.
Yes.
24 Parganas North. He makes the assessment for 3 days continuously. He does everything, takes into account the police report, surveyor, loss assessment, everything done. He comes to a loss assessment of a little in excess of 2.5 crores. And he also notes the fact that the policy records Murugacha village as Nodia. He records that, it incorrectly records it, but he proceeds to do that. And thereafter he says, then in his report, he recommends that this is the loss which according to him he has assessed. And thereafter he sends it to the insurance company. And the insurance company says that there is a mismatch in the place of occurrence and repudiates my claim. Now, my lord, how did this mismatch happen? Now, my lord, this is not a new policy. This policy has been then from 2019. In 2019-20, the factories which were covered under the policy includes Murugacha at 24 Parganas North. Now, what happened in 2021, the policy admittedly records Murugacha at Nodia. Now, I don't have a factory in Nodia. So, where is the question of including Nodia? So, eventually.
Do you have other plants also?
Nothing.
It's only one place where
No,
you.
my lord, I have other places also, but not in Nodia. I don't have anything in the district of Nodia.
All right.
Now, my lord, how did this happen?
Murugacha, and where else do you have your plant?
There are four locations where I have my factory. If your lordship will, if I may just trouble your lordship once with page 34.
And all 4 are insured.
All 4 are insured. If I may just trouble your lordship with once para 30. My lord, kindly take page 34, which is a part of the first policy. The policy starts at page 26.
I know. Kindly take page 34 once.
Yes, post office Bandipur.
My lord, kindly
Khordha.
see one is
Shashwat
carpet
North.
and drudget manufacturing. Then, my lord, kindly see,
Navda.
then carpet such and such, Golabari Bazaar. Then 3 is such and such, Boshirhat. Then 4, kindly see, carpet, cotton, Murugacha, Ghola, PS, Jugberia. Have your lordship found that, my
Yes,
lord?
yes.
Number 4. This is the place of occurrence. Then I have other premises also, my lord. I have another manufacturing unit in the other places. So Nodia was never my manufacturing unit. Now, what has happened where my lord, where it has happened, if your lordship will kindly take the next policy, which is the subject period, which is at 2021, starts at 36. The relevant portion is at 37. 36 is this policy was renewed for the subsequent year. Now, my lord, will kindly come to page 37.
Renewed and renewed. What is the period for renewal?
2021, if your lordship see page 36, period
Cover
of
note.
insurance.
Cover note. At
Yes,
the
cover
top.
note is at page 36.
Yes, 25th of January 21. And it ends.
Midnight of 24th of January 2022.
Where do I get that?
My lord, it's just like, my lord, towards the middle here, my lord, if your lordship, about just after below the address, Calcutta, West Bengal, just below that, period of insurance from, it's highlighted in fact. Page 36.
Yes, I get it.
Yes. And my lord, also kindly make a note, immediately to the right of the period covered under the policy, your lordship will find there is a column called broker.
Yes.
And your lordship will see a broker number is given.
Yes.
And it says Ideal Insurance Brokers Private Limited.
Right.
This is the second respondent in my writ petition. This is the broker.
Hmm.
Whose broker? It can't be my broker. It's an insurance broker, registered insurance broker under the IRDA rules of 2018.
All right.
Now, my lord, what happens if your lordship kindly takes page 37, which are the locations covered under the peril policy. If your lordship will see serial number 2 towards the middle of the page,
Yes.
one is that carpet and drudget manufacturing. First is, my lord, not 24, but kindly take the second one. It is said Murugacha, it has become Nodia. Now, my lord, kindly once take the, my lord, the surveyor's report, which starts immediately thereafter at page 40.
Is it the only reason, the mismatch of the
Absolutely,
address? There is nothing else.
Nothing.
In the opposition also nothing.
Nothing. And they admit that it is not my fault. It is the fault of the insurance broker.
Where is it?
Would your lordship...
Any rejection is there? Is any rejection of
Yes,
your
they
claim?
have repudiated the claim only because of mismatch of address.
Please show me that.
Would it be your lordship pleasure to first have a look at a few paragraphs of the report? Because this establishes the fact that there has been a fire, that it is well covered under the policy, and the assessment of loss has already been made and quantified. And he takes into consideration the fact that I have nothing in Nodia.
And in the opposition, this is not denied.
Not denied.
All right. You show me the rejection.
Kindly come to the affidavit in opposition.
Opposition.
Of the respondent number 1. This would be on behalf of the respondent number 1, if your lordship will see, Obhimanyu Shandilia.
The on-record advocate. Lordship.
If your lordship kindly take the trouble of coming to.
Yes, please. Lordship, Abhimanyu Shandilia is the on-record advocate, my senior. While traveling to the court today, he's a vertigo patient. He had some attack. That is the vertigo attack. It keeps coming, and when it comes, he needs to take. He cannot stand on
What
his
you
feet.
want?
If the hearing on our part could be fixed on Monday, your lordship, because it was completely. Unfortunately, he couldn't attend it today.
But then you are here, madam. You can continue, isn't it?
Lordship, I can, but I don't have the complete instruction from my senior, your lordship, for the entire matter. There are
Because
certain
whatever the instruction is in the brief. No further instruction inside your ears.
I beg your pardon, Lordship. There are certain facts which are, I am aware of the fact, but there are certain things which unfortunately I haven't discussed and I don't have the instruction.
Just wait, let him make some submission. I'll see what is to be done. Yes.
Lord, kindly take paragraph 23 at page 9.
Yes. Yes.
Lord, this is the reason for repudiation. With regard to such and such, my lord, kindly take respondent submits that the assessment of location covered under an insurance policy is not hypertechnical. The location mismatch is not some computer generated or automated mistake, but a result of the request of the, my lord, kindly make a note of this, my lord, but a result of the request made by the respondent number 2, which is the insurance broker.
It says the
Who is
agent
the-
of yours.
Well, my lord, if they say it is my agent, there cannot be, my lord, I cannot have an agent in an insurance policy. It has to be under the IDA rules, my lord. I have got the IDA rules. It has to be a registered broker.
Anyway, there is
It
a
cannot
mistake.
be. It's not permissible in
However,
law.
it is either yours or other his.
No, it cannot be mine. Like,
Yes, then what happened?
then
Petitioner had ample time to
who is
respond to
the
review
agent of the
documents.
petitioner? Then, moreover, the petitioner had ample time and responsibility to review the policy documents, details request. The answering respondent admits that the mismatch is in location wholly attributable to the insurance broker, the respondent number 2. The answering respondent further submits that the insurance broker is not an agent of the respondent number 1. Instead, he is the representative of the petitioner. Then, may I kindly take the second paragraph at page 10. It is pertinent to mention here that the petitioner had formally appointed respondent number 2 as its agent broker through a mandate letter of 15th of January issued by the petitioner in favor of respondent number 2, and the present petitioner has arisen due to sheer negligence and oversight of the respondent number 2, who should be responsible and liable for any loss suffered by the petitioner. So loss suffered not in dispute. Now the question is that whether it is the insurance broker respondent number 2, if it is his negligence, will kindly have a look at the letter which they refer to and annex it to the part of the affidavit in opposition. Your lordship will find this letter at page 102.
Yes.
Lord, it says it is the petitioner's letter to the broker. We hereby confirm Ideal Insurance Brokers appointment as our mandated insurance broker with rights and duties as per Insurance Regulatory and Development Authority of India Insurance Brokers Regulations. So this is a format that everybody has to sign. So I could not have written that as a insured. I am the insured. So if you lordship goes or I go to take an insurance policy, who do I go to? Either I go directly to the insurance company, like the life insurance company, or I go to an agent. These are the authorized agents of LIC or any other insurance company like the Oriental Insurance Company in this regard. So tomorrow the insurance company cannot turn around and say that I will not give you your claim because the policy or there was some mistake which has crept into the policy because of the mistake by the broker. It is your broker under the IRDA rules. So these are the certified licensed brokers.
Very well, I have followed it.
Now, my lord, your lordship will kindly see what the R2 has to say in their affidavit. That's why we made the second respondent a party to this. My lord, he admits. My lord, kindly once take paragraph 3 of the second respondent's affidavit.
Yes.
And kindly take the third paragraph.
Yes.
The second respondent is a reputed company engaged in the business inter alia insurance broking and is registered with the Insurance Regulatory Development Authority of India. As per usual industry practice, the insurance broker are to applies for and is allotted a specific broker code by the insurance company. I'm pausing here for a moment. If your lordship recalls page 36, I showed your lordship insurance broker in the package, in the policy. So the broker is a licensed broker. So only then the policy could be issued through the broker.
What has he said?
He says after obtaining such broker code, then he continues, then, where he says, well, kindly come to paragraph 6, about 4 lines from the bottom at continuing page 4. About 5 lines from the bottom of page 4, your lordship will see there's a sentence starting upon inquiry.
Yes.
It transpired that a member of the sales team of the answering respondent, namely Gaurav Kunda, had issued an email on 23rd January 2020 to the first respondent seeking changes in 2 policies. One of such changes pertaining to the location of one of the petitioner's factory. It is not clear why such email was issued when no supporting request or instruction appears to be on record from the insured company. If I had made a request asking them to change, that would have been different. But today, if you, my lord, kindly also appreciate today, if you make a change in the policy of the insured without any request letter from the insured, will you do that? Like, my lord, when we come and say, my lord,
Just wait. Respondent number 2, what is your stand?
This stand is one who person is looking after one officer. Mr. Gaurav, he has resigned and he has not disclosed.
No, listen, his resignation will not do. There is a claim. It is you who had acted as the agent. Now, what is your stand?
I would like to confirm the change of the address of verifying paragraph 6, my lord, I am referring here also. This explanation is given here.
Very well. When is your counsel coming?
Kindly fixes it on Monday. If my senior is not able, I will do the matter before your lordship.
Please come. আজকে কি ফাইল হলো? আজকে কি ফাইল হলো? Opposition by both? আচ্ছা। দুটো reply? একটা। If it were in opposition by the respondent numbers 1 and 2 filed in court is taken on record. Reply to the opposition of the respondent number 1 is also taken on record. Stop. Heard submission made on behalf of the petitioner on the prayer of the learned petitioner and the respondent number 2. On the prayer of the learned advocate representing the respondent number 1, hearing of the matter stands adjourned till 17th of March. কোনটা? সেপারেট তো ছিল। হ্যাঁ।
17th Lordship, there is some difficulty on 17th of March. If that could be changed, your lordship. Humble
Now,
submission.
whose difficulty is it?
There is some matter fixed. There was instruction for 17th and 21st.
18th.
Grateful, your lordship.
Grateful.
My lord, the matter has been resolved. The petitioner was not allowed to his bank account, and the respondent one is State Bank of India.
I'm appearing on behalf of
State Bank of India. So now the matter has been resolved, and the petitioner is allowed to his account.
What is your submission?
Well, problem has been resolved. Problem has been resolved.
Problem has been resolved. Learned advocate appearing on behalf of the petitioner submits that the grievance of the petitioner has already been redressed. Stop. Learned advocate representing the State Bank of India supports the same. Stop. Next. In view of the above, the instant writ petition stands disposed of.
Much obliged.
Your Lordship, I am appearing on behalf of this petitioner. Your Lordship, I have written instructions to withdraw the matter.
Why?
Your Lordship, the matter has been resolved, Your Lordship. The writ petition was filed because a certain amount was deposited by the petitioners in an account maintained by the petitioner before the respondent bank, respondent number 4 and 5. Your Lordship, the 7A proceedings has been initiated against the petitioner. So, Your Lordship, the petitioner had requested the bank to transfer the amount to the Central Board of Trustees so that it could help the petitioner in resolving the 7A proceeding. However, that was not transferred, but now it has been transferred.
Grievance redressed. Very well. Other side নেই ওই লাইনটা হবে না এই কমিউনিকেশন রয়েছে হ্যাঁ কি করব বলুন It should be 20 gone down as 80 or should be 80 gone down as 20? Which one?
So, that it should not be sugar control, because sugar control order they have power to search and seize, but the 20% notification is under the jute packaging act. We have proposed certain corrections. I have shown the other
That's a
side also.
notification and this will be 20.
Notification issued under section 3(1) of the JPM Act. Or jute packaging.
Acha, notice that.
The full name is now active namta ache to.
Jute Packaging and Manufacturing Act.
Jute packaging, jute packaging materials, open bracket, compulsory use in packing commodities, Act 1987. আমি লিখে দিচ্ছি। We should give it in right.
আচ্ছা ঠিক আছে এটা হবে না সুগার কন্ট্রোল অর্ডারটা হচ্ছে না এখানে এটা হচ্ছে আর এটা হবে 20% 80টা হবে না Apart from C-liner, is there anything else also?
Many others. C-liner is what they brought up, so there are.
Okay.
C-liner is the requirement.
One of the requirements. আচ্ছা ঠিক আছে
No, it's the requirement.
Depending on the price, but if they have something cheaper, there is B-liner, E-liner.
Only C-liner is our requirement, my lord.
No, how do you?
No, that is notification, my lord.
That's my submission. My submission is.
Only C-liner is appropriate for our use, your
It
lordship.
depends on tender. There are some tenders where they need other types also. I will show. There are some tenders where they need.
Only টা কেটে দিন just delete only
You have documents where there are other types of.
very well
Actually, C-liner is our badge for notification. C-liner is requirement of, my lord. Diplomat. হ্যাঁ দিয়ে আমি দিয়ে দিচ্ছি
I am for the petitioner, Your Lordship. Your Lordship, this is that GST amnesty scheme matters, Your Lordship.
who is your other side
Your Lordship, we have served, Your Lordship.
CKV
Your Lordship.
any idea who appears
Service is complete, Your Lordship. We have served them after notice also, we have served them. After mentioning also, we had informed them and.
where is the order that is being passed by this bench
Your Lordship, in another matter, Your Lordship has been pleased to keep the matter returnable on 17th. Your Lordship, one of the orders I'm sharing.
Your Lordship, the only thing is here, Your Lordship, we have to corroborate the claim from the orders of GST.
There is nothing from their end?
From their end, we don't have anything in this matter. So, Your Lordship, I've annexed the GST orders at page 17 and page 33. Your Lordship, I'll point out. Your Lordship, the order starts at page 17. At page 30, Your Lordship, serial number 3.
Yes.
Your Lordship, at page 30.
Yes.
Serial number 3 is our claim against the university.
Yes.
Similarly, Your Lordship, the second order is at page 33.
What will be the bill amount?
Your
This
Lordship,
is
summary is at page 58.
38.
Your Lordship, there are 2 orders, but my claim is for 3 years. So, Your Lordship, at page 58, Your Lordship will find.
Give me the figure.
Figure is 70,94,000.
Where do I get that?
Your Lordship, at page 58 is the summary. The bills are at page 49, 50, 51. And Your Lordship, we can match the figures for 2 years from the orders of the GST authorities. For third year, they have not initiated any proceeding.
All right.
Yes, Your Lordship. So, Your Lordship, one by one, I'll show Your Lordship. Page 17 is the first order. At page 30, we get the amount. Your Lordship, serial number 3 is Bidhan Chandra Krishi Vishwavidyalaya. Amount is 8,33,974. Your Lordship, 9% is CGST, 9% is SGST. So, Your Lordship, this is doubled. Your Lordship, similarly, Your Lordship, the second order is at page 33, relevant at page 47, serial number 1.
So total comes to 70,94,503.
For 3 years, Your Lordship. But for 2 years, it comes to 42,38,698.
And third year, they did not claim.
Third year, GST authorities have not initiated any proceeding against me.
As of now.
As of now.
So if you subtract this third year, how much is the figure?
Your Lordship, 42,38,000.
Bidhan Chandra.
Yes, my lord.
What is your instruction?
My lord, today I have received the brief, my lord. This matter relating to GST, my lord, not to be paid, my lord, within 31st March, my lord.
Yes.
Your Lordship, kindly take up this matter and Tuesday, my lord, in the meantime, I will take
Your Lordship,
instruction.
may I have a suggestion? Your Lordship would kindly direct them to pay and keep the matter returnable on 17th. Your Lordship, 2 matters are already fixed on 17th.
How can they pay within such a short period of time? It's not possible.
Your Lordship, Your Lordship, the invoices were raised much before, Your Lordship. Your Lordship, the only difficulty was that the petitioner is a senior citizen. He was in and out of hospital, Your Lordship. And Your Lordship, as the...
you calculate the figure first.
Yes, Your Lordship. Your Lordship, for the first 2 years where orders are
2
passed,
years.
Your Lordship, I've calculated.
It is?
Your Lordship, it is 42,38,689.56.
42,38,000?
689.956. And Your Lordship, if we take the third year, 28,16,000.
That is separate. That is separate. The figure is here, I can see. And this is for the year 17 and 18.
17, 18 and 18, 19.
Yeah.
No, page 58 does not show anything of 19. It's 17 and 18. The
Your
first
Lordship,
two.
kindly see, Your Lordship, tax period. The fourth...
March 18. All right, I can see. July 17 to March 19.
Your Lordship had directed that they will pay directly in GST portal, Your Lordship. I am not getting any money, Your Lordship.
Please come.
The only thing in item number 7, I'm appealing. My lord,
No, my lord, it is not same, Your Lordship. Your Lordship, all claims are separate, Your Lordship.
Petition are the same. If some orders, I saw the petition is the same.
Petitioner is same, Your Lordship, but the respondents are separate.
4, 5, 6, my lord.
4, 5, 6, 7 is separate.
The petition, because the issue is
Separate. Answer. The petitioner intends to avail the benefit of the amnesty scheme that is prevailing. Amnesty scheme of the Central Board of Indirect Taxes and Customs, comma, GST policy wing that is prevailing at present. Stuff. The petitioner supplied certain goods to the
Your Lordship, services.
services. Bidhan supplied certain services to the Bidhan Chandra Krishi Vishwavidyalaya. But the service tax for the period July 17 to March 19 has not been paid by the university. Stop. The petitioner prays for a direction upon the university to pay off the service tax by availing the benefit under the amnesty scheme. Stop. Learned advocate representing the university seeks time to take instruction. Paragraph. Each one number paragraph. As it appears that the university
Your Lordship, other entities have already paid in some matters, Your Lordship.
Very well. In view of the above, the university is directed to pay off the GST amount of rupees 42,38,689,56 by 21st of March, released on 25th. ফিগারটা এইখানেতে বললো আমি লিখে দিলাম, এই দুটো অ্যাড হবে, এই যে হ্যাঁ দুটো ফিনান্সিয়াল এটা মাইনাস হয়ে যাবে। সার্ভিস ইজ টেকেন অন রেকর্ড। হ্যাঁ 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 ঠিক। Yes, next one, what is the figure and what is the period?
Item 5, I am the ICR. Lordship, I am for the ICR. Lordship, I did not receive the complete brief. Matter may be adjourned, Lordship. ICR is different. ICR is, on verbal instruction I received that matter GST is related to 13 to 16 when GST Act was not applicable. The matter may adjourn, Lordship. Next day, 18 March may be fixed. I have not received the complete brief.
Your Lordship, here, although the claim is 3
Day
lakh.
Day before yesterday, my cataract operation is done. Lord.
82 rupees. Your Lordship, order relevant portion is at page 30, serial number 11. Your Lordship, National Dairy Research Institute, NDRI, 33,541. Your Lordship, 9% is CGST, 9+. So, Your Lordship, the amount is 67,080 and 82 rupees.
67,082.
67082.4.
0.4.
Your Lordship.
All right. What is your submission?
Lordship, I have not received complete brief. First, I said, Lordship, on verbal instruction, they said that GST they claiming it before the GST Act come in the force.
When, for which period is it due?
1718, Your Lordship.
1718.
Lordship, matter may adjourn for 18. Lordship, I will.
That's at page 16, Your Lordship. Your Lordship, for in the second line, for the period 1718.
Page 16?
Page 16.
Yes.
Your Lordship, this is the order. Your Lordship, on the top, order for DR7. Your Lordship, towards the end, for the period 1718.
Yes, 1718.
Your Lordship, I had placed there.
Your bills, where are your
at page
bills?
30. Your Lordship, the bill is at page 48.
Bill is at page 48.
What GST authorities have claimed is much less. So, Your Lordship, I am praying for what the authorities have claimed.
Please come. Period is 1718. Authority is NDRI. NDRI, page 30 te. 11 number. Figure is 67082.04. আর কিছু নেই তাহলে এটা থাকবে ইয়েস ওনার অ্যাপিয়ারেন্সটা রেকর্ড করে নিন
Your Lordship.
6.
Yes. Your Lordship, yes. Your Lordship, here also for 3 years we have claimed. Order is for 2 years. Your Lordship, at page 15, the order starts at page 15. At page 29, Your Lordship will find serial number 12.
Page 29, serial number 12.
12, Your Lordship.
Herbal Garden.
Your Lordship, National Institute for Homeopathy. Your Lordship, 72,450 into 2.
Yes.
And Your Lordship, for the next year, Your Lordship, the order starts at 31. Your Lordship can straight away take page 45.
Yes.
Serial number 8, Your Lordship, 69,685 into 2, Your Lordship.
How much is the figure?
Your Lordship, the figure is 2,84,270. 2,84,270, Your Lordship.
270. And period is 1718?
1819. Your Lordship, I have a claim for 1920, but
they have not touched.
Yeah,
So 18 and 19.
Your Lordship. Invoices, Your Lordship, at 4748.
Where is your service?
Your Lordship. Your Lordship, here the institute has received, Your Lordship. One of the respondent, Your Lordship, main respondent is the Institute of Homeopathy. And Your Lordship, the respondent number 1, Union of India, Your Lordship.
The National Institute of
In
Homeopathy.
return.
Union of India has returned.
But the institute has received, Your Lordship. Your Lordship, we had also informed after, Your Lordship, the mentioning was allowed by Your Lordship.
Very well. Service none for the respondents. Yes, 7.
7, Your Lordship, my learned friend is here.
Yes.
Your Lordship.
First of all, there are, I don't know other matters. Here I find there are 2 adjudicating orders, GST, saying the liability is with him. They have not preferred an appeal. The orders are of 2022.
We have preferred appeal, Your Lordship.
This is not on record. If they have preferred
Your
an
Lordship,
appeal,
but I can still apply to amnesty.
No, kindly, my lord, just please, my lord, kindly come to page 16.
60?
16.
16. Yes.
My lord, which is, this is an order of dated 5th April 2022. My lord, whom, my lord, they have not issued, annexed the show cause notice. Within 1 day, I could not get arranged. But kindly, my lord, in respect of Shivani Chakravarti, my lord, the petitioner here. So there is, ultimately, after considering all aspects, whether this comes under exempted supply, an order has been passed. My lord would find the last.
He does not want exemption.
No, kindly, my lord, What he is trying to say that the liability is on the third party. Without.
To whom the service was given.
My lord, under what law?
I am saying, Your Lordship, GST authority, my learned friend appears for GST authorities, Your Lordship. GST authorities are saying this. It is the GST authorities order.
Yes,
my lord, kindly allow him to show GST authority says this is the order, this is the amount that is taxable.
Your Lordship, I have annexed at page 30.
Listen,
Your
whatever the money will go, it will go to your account.
My
It's
lord,
not that the money is not going to come to
kindly,
the petitioner's account.
Well, there cannot be a shortcut. There's an adjudicating order, there's an appellate forum. If he says it is not my liability, if she comes up and says it is not my liability, has she preferred an appeal? This is order of 2022. My lord, today a scheme has come up where says the waiver of interest. 2022 order she is trying to get implemented. Have she preferred an appeal? Answer, my lord, in the pleadings there is nothing on record. My lord, next. Kindly see the next order.
again dated 5th April 2022.
Yes.
Now question is, my lord, if the my lord, kindly then allow me to place the order, because
Why?
the
What
order,
is the
my lord,
use?
the order says liability is with her. If it is like, my lord, then I will come. Now my lord has to also consider the contract. If it is a fixed rate contract,
Why go into all
my lord,
these
kindly
things?
see, kindly, my lord, if it is a fixed rate contract where the money is inclusive of the tax component, then the, my lord, the concerned respondents are not liable. Has she disclosed the contracts? My lord, I am protected by a judgment of the coordinate bench where this very issue had come up, and it has come to a conclusion that fixed rates contracts are prevalent where tax is inclusive.
Yes.
If the tax is inclusive, my lord, then she is liable. The liability, my lord, where is the avowment that where is the contract?
Very well, you are for the authority. You are not going to pay.
No, my lord.
Are you for the
Yes.
authority who has
My lord, kindly, he has
enjoyed
now
the service?
annexed State of West Bengal through Public Health Engineering Directorate.
Public health is not required to pay. It is the Janashastha Karigori Bhavan where the service was rendered, possibly.
No, that is the office, my lord.
Your lordship, the invoice is at page 48, 49, your lordship.
48, 49.
To the executive engineer, resource division,
that is
PIC
what,
department. Your lordship, then
Invoices as
all
received.
the other organizations are paying up, your
My
lordship.
lord, the question
Then
is,
it is on
no, my
forward
lord, I have
charge
taken
basis.
a point of law.
If the grievance is, or if the claim is that it is you who is to pay and
Your
not
lordship,
the
I'll explain this.
authority.
Your lordship, forward charge basis means that I will collect it from the service recipient, and your lordship, I will pay to the authorities.
Provided it is there in the contract.
Your lordship, that is the law. Your lordship, what had happened is, your lordship, when the GST Act came, there was a confusion that these educational institutes and government institutes are exempted from service tax, because your lordship, under the service tax regime, they were exempted. So, your lordship, in this confusion, your lordship, several organizations represented that they are not liable. And they were also under the impression that they were not liable. That's why, your lordship, in our original bills, GST component was not there. Then thereafter, your lordship, when the GST authorities initiated proceedings, we raised demand and supplementary invoice on all the organizations. Some had paid voluntarily, some had paid pursuant to your lordship's order. And your lordship, my learned friend's client is one of them. Respondent number 2 is one of them. And your lordship, all that money will go under the scheme to the GST authorities only, from the government to government, your lordship. I will just be relieved.
The government wants it from you. The
Your
government doesn't want it from one department to the
Your
other.
lordship, I am not liable. Liability is on the service recipient to pay.
Now, if there is an issue with regard to
Your lordship, I have raised the invoice. I've annexed it at page 48. Have they ever disputed it, your lordship, that these invoices, they are not liable to pay under the invoices? The invoices
But then
were
the
raised
order has been passed.
2022.
your lordship, yes. Orders have been passed. Your lordship, I am challenging, but I will apply under amnesty. Because, your lordship, I want to come out of litigation. And, your lordship, the order also imposes penalty and interest. Now, your lordship.
And the appeal is pending.
Appeal is pending, your lordship.
My lord, there is no
Your
document to
lordship,
that
let's
effect.
come before the High Court only, your lordship. I can, if your lordship directs, I can bring those cause papers, your lordship, where for some reason.
Give the details of the appeal.
My learned friend appeared for
My lord,
this.
I do not
for
remember. I
JP,
appear 5 to
He appears so many
so many
matters.
matters, your
Right.
lordship, not like us.
To give the numbers
Yes,
so
your
that he can
kindly see-
understand.
My lord,
Hold
kindly see what is the
Your lordship,
findings of the page 46. My learned friend says it was not a forward mechanism was applied. RCM, my lord, would kind in the above supply. After the first
Yes.
above supply of service was treated as taxable service at the time of issuance of show cause notice in absence of proper documents. But the RTP has produced relevant documents in support of the claim which relies submitted against the show cause notice. This is the submission is considered at this stage before creation of demand order. The final details of the inward supply stands after subtracting zero rated supply of service
Outward
and
supplies.
services on basis of RCM. It is a reverse charge mechanism has been applied. My lord, this matters, my lord, cannot be. My lord, I was surprised by this is a group 4 matter. First of all, my lord,
This is not a
my
group
lord,
4 matter,
what
your
is,
lordship.
my lord, where is the contract? Has
Your lordship,
she
my
disclosed?
demand for justice is there. They have never replied
Contract
at
and demand for
55, your
justice are
lordship.
same.
Your
But
lordship, I have made a demand repeatedly. Your lordship, at 50, at 55, they have never replied, your lordship. And your lordship, everybody has paid.
My
All
lord,
the central
my lord,
government
my lord,
agencies have
kindly,
paid.
my lord,
Your lordship, this is
my lord,
peculiar with the state government.
What can be done?
Yes, your lordship.
It
Your
cannot be
lordship,
done.
let them file affidavit, your lordship. What else can I say, your lordship?
Very well, let them file affidavit. the petitioner intends to avail the benefit of the amnesty scheme. Avail the benefit of the amnesty scheme by the Board of Indirect Taxes, which is prevailing at present. Stop. Learned advocate representing the respondents opposes such prayer. Stop. Let affidavit in opposition be filed within a period of 4 weeks. Will be all right with you? Reply, if any, within 2 weeks thereafter. So your scheme is gone.
Your Lordship, this is one of the straight, Your Lordship, small amount. I think we can still apply, Your Lordship. Grateful.
Yes.
Well, I appear to be in this matter, Learned Advocate General appears this matter. He is requested to color kindly. Requesting my lord to adjourn for the day, so that
Adjourn for the day.
That,
It is appearing under the heading urgent motion. It's urgent.
very urgent, Lord. It was mentioned because, Lord, they might, Lord,
no,
award the tender.
No, our tender is open on 13th.
No, the only
13th,
financial bid
my
has not
officer
been
is
opened.
there.
If they open the financial bid and they
Financial
award, that's the reason.
No,
it has,
financial bid open on 13th.
financial bid has not been opened. It's the
It will be opened on the 13th.
13th.
It will be opened. Not opened, it will be opened on the 13th.
13th of March.
Yes,
13th
yes.
of March.
Okay, I'm sorry.
It will be.
It
It will be opened on the 13th of.
So Lordship convenient, Lordship can fix it.
But
No, today is convenient.
Today is not available. Learned Advocate General is not available.
Then what to do?
It is my duty,
Which day
madam.
can you come back? In fact, my lord, my learned friend is coming from Bombay, so I just asking him. He went in before 13th. Any day? Tell me. 12th. 12th. Could it be on the 12th, my lord?
Very well.
As an urgent motion. my lord?
Yes, yes. Please come. On the prayer of the learned advocate representing the state respondents. List the matter on 12th March under the heading urgent motion. Is there any other respondent who is to answer?
No, my lord, it is the state. Because, my lord, I have come against the rejection of my technical bid. That's the stage. But financial bid has not been opened as yet. So, my lord, there can't be any other party.
At a line legal it has been submitted by the learned advocate representing the state respondents that the financial bid will be opened on the 13th of March 2025.
Much.
Service is taken on record.
Need to do the slip, sir. 9 or 10 of the similar matter. I see last day's order, my lord. I have complied with, my lord. I have given a. It is fallen from themselves that they do not want that money from the foreign country. Now to remember the bill, LC.
Yes, yes.
So they do not want that. Let them write a letter
Letter of
that
credit.
I do not want that amount. And
for the petition.
Yes. So it is simple. I have simplified the issue without going into hyper technical issue. That. Simply, they have to write a letter, which I cannot write it here, that they do not want the money and account can be write off. So we'll forward that to the RBI. Now the RBI has to take a call. Both the matters.
Did you receive this letter, 5th of March 2025?
Yes. I've sent through mail. I've given copy.
Just now
My officer is there. I have instruction that I have sent it in my mail. I am given a copy.
Tell him not to make submission. You are there. Very well. There is a communication from the bank
Yes, madam.
which mentions that as per the RBI master circular, you can approach the RBI to write off the bill, after which the account can be closed.
I have sent through mail. That is the.
Sent through mail. Please come.
More simplify, my lord. They have to write why they do not want that money from the foreign country. Because
Guide them as to how it is to be done.
only thing that they do not want that money, that is to write off. Why
Yes.
not? Because the RBI has to take a call, not the PNB.
Acha, the communication dated 5th March 2025
দেখুন এখানে দেখুন।
by the authorized signatory of the Punjab National Bank.
Overseas branch.
Acha, Punjab National Bank within bracket a overseas branch addressed to the petitioner has been brought to the brought on record. Stop. The communication mentions that as per the RBI Master Circular number 10/2011-12 dated 1st July 2011, the petitioner may approach the RBI through the, what does AD?
Advisory bank.
Advisory bank one.
Overseas branch only.
Through the bank
Advisory branch.
advisory branch to write off the dues of the disputed bill. Stop. The account can be closed thereafter. Stop. The reason for writing off the dues is required to be mentioned in the letter to be addressed to the Reserve Bank of India. Stop. The writ petition, the petitioner is to take action in terms of the RBI Master Circular mentioned herein above. Stop. The writ petition stands adjourned till 25th of March 2025 for recording further updates.
One thing, subject to question, may I pray? In the meantime, whether there is any dues in connection with this account or not?
Nothing.
No dues.
Only that I'll see.
That should be so I can, my credit score is down, is coming down.
No, he says there is no dues.
That communication is not, it is only, but I record that it is
That is in the letter also. In this letter, it is there. Can you see the letter?
Yes.
That is the only dues.
Yes.
First, third line.
Acha.
They themselves admitted in the writ petition also.
According to me, there is no dues, but there is no.
Except this foreign bill.
That is.
The letter clearly mentions that apart from the disputed foreign bill mentioned, bill number of which is mentioned in the communication dated 5th March 2025, there is no other due from the petitioner.
So, my lord, the petitioners may be disposed of, my lord, there is no point keeping the petition.
No point, but just to see if things have worked out or not.
Them to go to our
You guide him, guide him properly as to what is to be done, so that we can finish it off.
Rightly mentioned that why not they want the money from them. Now the RBI will take 6 months to decide this.
Let him forward, let the RBI take steps, and he'll come once again for getting an order against the RBI.
Okay. RBI is not a party also here, so.
That is the reason a next writ petition will come. 10 is same.
Look, the order was passed on 24th September, which was extended by this court on 12th of February. Now, look, they have filed their opposition.
Yes, we have, your lordship. On the last occasion, the state respondents were supposed to file a report.
Report has not been filed, and would take some time.
28th of February was the time within which you had to circulate it.
We've done it.
Yes.
You have circulated?
Other report. Why did you?
State, your lordship, the state respondents were supposed to give a report. We have given an opposition.
Who are you?
He's
I'm
the private
for the
party.
private parties.
Oh, you are the private parties.
Now, since this is not from Kerala, she kindly give us not at least 4 weeks time to file the reply, and then let it be fixed any date.
State is not appearing also.
I'll inform them.
You?
Mr. Samrat Sen was available.
On the last occasion also, nobody
Last occasion, I find Manali Ali is.
Yes. Junior was there, but she had no
It's a
instruction.
pure question of law, but since an affidavit has
Please
come on
come.
facts, let us not.
The report of the respondents have not been filed till date. Stop paragraph. Do you want to file a reply? Do you want to file a reply to the private respondents?
I shall.
Acha. The petitioner will be entitled to file an exception to the affidavit that has been filed by the respondent numbers 3 and 4. Stop. The hearing of the writ petition stands adjourned to allow the learned advocate for the state to come up with a report by way of affidavit. Stop. The interim order that is subsisting is extended till 31st of July 2025 or until further order, whichever is earlier. Liberty to mention the matter for hearing.
Keep your place. কিছু বলবে? একটা চলে যাচ্ছে, ঠিক আছে।
On behalf of the state, your lords.
My lord, item number 12, my lord, I am for the petitioner. My lord, everything has been paid as per your
And
lordship's
Mr. Bitu is
direction,
there in online, your lordship. So,
including the earnest money and as well
state direction to file the report.
So far my knowledge.
Please come. Learned advocate appearing for the petitioner submits that all dues of the petitioner have been cleared. Stop. In paragraph, in view of the aforesaid submission, the writ petition stands disposed of. Somebody is present virtually. Who is he?
Yes, my senior, Mr. Shogoto Mitro. I have the report, your lordship.
My lord, I am the additional district magistrate, Pro Mendipur. I was asked to be present virtually in this hearing.
Yes, you are the additional
District
magistrate. All right. The ADM within bracket ZP Purva Mendipur. What is your name, sir?
Anirban Kole, madam.
Anirban Kole is virtually present. Stop. His appearance stands dispensed with.
Thank you. Most obliged, madam. My lord.
Your lordship, your report.
My lord,
Give
this is the
report by
bank
these-
statement order that should be kept.
Acha, keep whatever is filed in on record. Keep it on record, all documents. দেখে নেবেন কি কি আছে।
Get phone.
In this matter, my lord, I beg to appear on behalf of the state, my lord, learned.
Your lordship,
Advocate General is leading me, my lord. My lord, I am praying my lord on 20th. Interim order is till 30th.
20? 20 is a Thursday. It's impossible. All contempt matters are
My
taken
lord,
up.
my learned friend suggested the date.
No, 20th is impossible.
Then
Can you take it up on the 21st then?
Friday, 21st?
My lord.
Very well. By consent of the parties, release the matter on 21st.
My lord, kindly, my lord, keep the exception, my lord,
Yes,
on record, my lord.
exception of the
Yes, sir.
petitioner to the affidavit
Yes.
filed by the respondent number 6 is taken on record.
But the affidavit, my lord, is not in form. The affidavit itself, my lord, is demonstrative of contempt because there was a specific express order directing the SP to file the affidavit. The affidavit has been affirmed by the additional SP, my lord. Similar
lord,
thing happened, my
Let
lord.
me see.
Similar thing
And my
happened, my
lord,
lord.
I have raised in the first day the maintainability of the writ petition.
Very well. Maintainability comes later. First comes the dignity and majesty of
Yes.
justice.
Yes.
Right, 21st. But the interim order passed, my lord, it's already continuing till the 30th of April, my lord.
Lordship, I am for the petition, your lordship.
I'm for the state mandate from Lordship.
Lordship kindly remembers this matter was taken up last Wednesday, your lordship,
This matter relates to the
Arms
Act.
raised.
Yes, your lordship. It was cancelled, your lordship.
Was
that
it deposited? Was the arm deposited?
on Friday, on that next day itself.
Next day, by tomorrow within
Yes.
5 p.m. was the time it has been done.
Surrendered everything.
Surrendered.
Yes. Now, your lordship.
You want to file a supplementary?
There's a direction, your lordship, to file a supplementary. Lordship, may I just give the gist of the fact, my lord?
No, I am aware of the gist. What about the copy?
I've served.
All right. Yes. What has happened? Anything has transpired?
Lordship.
Has anything transpired?
Transpire means, your lordship.
Pass it over for 5 minutes.
All
My
right.
clerk is coming. Brief.
All right.
Only 5 minutes. I am here.
Yes.
And only before my learned friend starts, my lord, there's a subsequent event which has happened. I'll just place that on record, my lord. There's a third bench which is to come up, my lord, now. So, my lord, may I just hand over? This is the appointment of a judicial member. Lordship will kindly take page 4 of this. My lord, since it was also argued on behalf of the petitioners that there were no more than 2 benches, so there has been overall appointment of the judicial members. And now, if your lordship kindly takes page number 3, page number 4 of this document, my lord. Kolkata Division Bench, New Court number 3. Judicial member has been appointed. Now, if your lordship kindly turns over at page 5. Now, D and E. In Mumbai, similar thing has happened in Mumbai also and in Kolkata, my lord. So, these 2 places, because of lack of infrastructure, instructions are awaited. This is a subsequent event, my lord. I'm just putting it on record.
D&E.
My lord, D&E.
A single member will be specific order for hearing as per the direction of the Honorable President to be issued. Single member will be given a specific order for hearing.
My lord, what has happened is there are 2 rooms here, my lord, basically in the present location in Kolkata, since we are concerned with regard to Kolkata. Now, there's a third bench which is about to sit, my lord.
Right.
It was a point of argument on behalf of the petitioners that
There are no
Yes, yes.
judicial members and
Yes.
members not available.
Yes, so, my lord, this also happened, my lord. I'm just putting it on record, my lord. Great.
Yes.
Mark করা আছে। Kindly give me 1 moment.
We are at the reply stage only.
Yes, my lord. We are at the reply stage. Now, my lord, I am not, my lord, troubling your lordship, my lord, with my arguments. Your lordship has heard that copiously.
Yes.
So I don't want to, my lord, again trouble your lordships. My lord, but give me, my lord, half a minute's time to just summarize, my lord, what I had essentially said. My lord, essentially, our writ petition seeking to challenge, my lord, the transfer of the NCLT from the present premises, my lord, to the corporate bhavan was founded, my lord, on 3 grounds. The first ground, my lord, was that, my lord, there is sufficient infrastructure present, and, my lord, the premises is being shifted to a distance of about 20 kilometers from here, where, my lord, there is nothing developed. That was one, my lord, limb of our argument, my lord. We have annexed photographs and other things to show, my lord, that that area is completely barren. It's in the middle of a field, my lord, that a swanky building has come up. My lord, the second limb of our argument was, my lord, premised on 2 Supreme Court decisions. One in the matter of, my lord, Madras Bar Association, and the other in the matter of, my lord, Swiss Ribbons, which, my lord, stated that, my lord, a tribunal must be formed under the aegis of the Ministry of Law and Justice and under no sponsoring ministry. So, my lord, it doesn't mean that, my lord, if a labor tribunal is to be formed, the labor department will form it. Or, my lord, if a customs tribunal is to be formed, the customs department will form it. Formation of tribunals, my lord, is a duty vested squarely, my lord, on the Ministry of Law and Justice. And, my lord, one of the, my lord, reasons given was that, my lord, otherwise, my lord, there would be some kind of pressure, my lord, from the parent ministry, my lord, and, my lord, there would perhaps, my lord, be, my lord, some, my lord, imperfection in the dispensation, my lord, of justice. The third limb of my matter, my lord, is also premised, my lord, on, my lord, the two decisions of the Supreme Court, my lord, which say that, my lord, no infrastructure of any nature whatsoever can be, my lord, taken, my lord, from the parent ministry. And this, my lord, was coupled with an obligation that, my lord, necessary, my lord, infrastructure and even, my lord, enclave, my lord, would have to be formed, my lord, within a specified period of time. My lord, these were, my lord, in short, my lord, the three, my lord, broad parameters, my lord, of my submissions. And, my lord, the principal point that we were trying to argue is that, my lord, if there is a mandate by the Supreme Court, then, my lord, unless, my lord, that mandate is modified or altered or done away with, then, my lord, like all of us, my lord, the ministry is also, my lord, completely bound to, my lord, act in terms of that mandate. Now, my lord, in reply, my lord, the first thing that I want to point out to your lordships is not one word has been said as to why, my lord, these two orders of the Supreme Court can be, my lord, ignored by, my lord, the central government. Because, my lord, it is our contention that, my lord, the shifting, my lord, of the entire, my lord, premises to the corporate bhavan, my lord, is in the teeth of this order. So, my lord, there is not, my lord, one word as to why, my lord, these two decisions don't apply to their case. My lord, having said that, my lord, I will perhaps at, my lord, the end of my submission, my lord, revisit, my lord, these two decisions, my lord, for a minute or so. But, my lord, I'll tell you, lordship, my lord, what their basic argument has been. My lord, their basic argument is just twofold. Number one, this point with regard to, my lord, parent ministry, my lord, not being permitted to, my lord, form the tribunal is not taken in your pleadings. So their preliminary point, my lord, which forms the sheet anchor of their defense, is that there is a lack of pleadings. And therefore, if there is a lack of pleadings, there is nothing that you can do about it. You can't argue this point. That's their principal defense. The second line of defense is, my lord, that, my lord, this is a policy decision. And if it is a policy decision, then, my lord, courts, my lord, will not, my lord, normally touch a policy decision. My lord, these are the two things, my lord, I have to counter. And, my lord, in support of their contention, they have given, my lord, 3 cases. Now, my lord, coming to the first question, my lord, that of, my lord, there being lack of pleadings. My lord, kindly, my lord, permit me to say this at the very beginning. My lord, what is my point? My lord, if I had wanted to argue a point of fact before your lordship, and if, my lord, the necessary pleadings and the documents in support of those pleadings, my lord, were not there, then certainly, my lord, your lordship would not have permitted me, my lord, to take your lordship's time. But, my lord, if I am, my lord, showing to your lordships an order of the court and saying that you are bound to act in terms of an order of the Supreme Court, 2 orders of the Supreme Court, then respectfully, my lord, that is purely a question of law as to whether or not, my lord, a tribunal with regard to, my lord, insolvency and company matters can be formed by the parent department being, my lord, the Department of Corporate Affairs. That is, my lord, purely a question of law arising out of 2 decisions of the Honorable Apex Court. And therefore, my lord, it is our submission that, my lord, if it is, my lord, based on, my lord, points of law founded on, my lord, Apex Court decisions, then, my lord, that, my lord, does not have to be specifically pleaded. In any event, my lord, I will show to your lordship that I have taken the point, my lord, that, my lord, this cannot be done. Have you got the CPC? CPC? My lord, may I first... Now, my lord, may I first, my lord, start, my lord, by inviting your lordship's kind attention. The CPC. Take out the CPC. My lord, kindly first have, my lord, Order 6 Rule. Order 6 Rule 2. Your lordships have it. My lord, Order 6 deals with pleadings generally. And Rule 2 states, my lord, every pleading shall contain and contain only a statement in a concise form of the material facts on which the party pleading relies for his claim or the defense, as the case may be, but not the evidence by which they are to be proved. So, my lord, kindly see, my lord, the choice of words, my lord, employed by the legislature. Every pleading shall contain only. Kindly, my lord, mark the use of the word only. Therefore, my lord, one does not have to clutter the pleadings, my lord, with, my lord, everything under the sun. Only a statement in a concise form. So, my lord, I am emphasizing, my lord, only. I am emphasizing concise, on which the party pleading relies for his claim or defense, as the case may be, but not the evidence. So, my lord, specifically excluded. So, my lord, I am only required to say, with the utmost of respect, that, my lord, the shifting of the corporate bhavan of the tribunal from its present location over there is bad in law. Beyond that, my lord, that is my case. I am not required to plead the evidence. I am not required to plead the law. That is, my lord, evident, my lord. I know, my lord, we cannot, my lord, wholly, my lord, take the civil procedure court and, my lord, fit it in the writ jurisdiction. The writ rules have been framed by your lordship's court separately. But, my lord, the basic principles of the civil procedure code always apply. My lord, having, my lord, invited your lordship's attention, my lord, to Order 6, Rule 2, my lord, আমার নোটিংটা কোথায় গেল? নোটিং এর কথাটা আমার নোটিংটা বের my lord, the proposition of law, my lord, as I, my lord, understand it to be, is that, my lord, just because, my lord, Order 6, Rule 2 says that you don't have to include, my lord, anything but the pleadings in their precise form, it doesn't mean, my lord, that you can, my lord, altogether do away with. I concede to that. My lord, my submission for your lordship's consideration is that a point of law is to be pleaded only, my lord, when it also includes, my lord, a factual aspect. And that factual aspect, my lord, in that case, my lord, if it is not pleaded in support of the point of law, then perhaps the point of law, my lord, cannot be urged. So, my lord, if I am, my lord, arguing a point, and, my lord, if, my lord, there is, my lord, a need for your lordships to understand, my lord, that the factual aspects, my lord, forming the substratum, my lord, of the issue that I'm arguing, is, my lord, required, my lord, to be proved or, my lord, to be demonstrated to your lordship, and that is not present, then, of course, my lord, your lordships can refuse to, my lord, make a further inquiry into the matter.
Very well.
But over here, my lord, there is no fact involved. The factual matrix, my lord, is not in doubt. My lord, in support of this, my lord, kindly have, my lord, 3 decisions. My lord, the first is, my lord, 1988 4 SCC 534. আমার কপি একটা দাও। জজ সাহেবের কপি। My lord, kindly have, my lord, the judgment straight away at paragraph 13. As has been already noticed, although the point as to profiteering by the state was pleaded in the writ petitions before the High Court as an abstract point of law, there was no reference to any material in support thereof, nor was the point argued at the hearing of the writ petition. Before us also, no particulars and no facts have been given in the special leave petitions or in the writ petitions or in any affidavit. But the point has been sought to be substantiated at the time of hearing by referring to certain facts which are stated in the said application by HSIDC. In our opinion, when a point which is ostensibly a point in law is required to be substantiated by facts, the party raising the point, if he is the writ petitioner, must plead and prove such facts by evidence which must appear from the writ petition, and if he is respondent, from the counter affidavit. My lord, this respectfully, my lord, would in my respectful submission, my lord, be the my lord, the ratio decidendi, my lord, of this decision. My lord, I'll repeat it with your lordship permission. In our opinion, my lord, this I'm reading from the 5th line from the top. 7th line from the top. In our opinion, when a point which is ostensibly a point of law is required to be substantiated by facts, only then, my lord. Then, my lord, if it is not pleaded, then, my lord, I cannot perhaps, my lord, trouble your lordship with it. My lord, the second judgment, my lord, in this regard, আমি বলছি সব বলবো CHN টেস্টে CHN তাহলে 1942 Madras আছে 1942 Madras My lord, permit me, my lord, to invite, my lord, your lordship's attention to, my lord, a very old decision. My lord, this decision, my lord, kindly have it at. It's a short decision. My lord, kindly have it, my lord, from the second page, 397. My lord, from the left-hand column, second paragraph. But my lord, may I, my lord, start, my lord, by first showing your lordship, my lord, the head note. My lord, kindly take the head note. My lord, held that the defendants were not stopped from pleading that the civil court had no jurisdiction to entertain the suit on the ground that the land on which the rent was due was a part of the estate, there being no question of a person being stopped, on a point of law or jurisdiction. The defendant's previous suit on a point of fact, but only in respect of the view of the law on the recital of the plaint itself. There could be no estoppel preventing them from questioning the jurisdiction of the civil court. So, my lord, what it essentially says is that, my lord, jurisdiction and, my lord, point of law, my lord, is not subject to the rule, my lord, there can be no rule of estoppel against it. This is, my lord, of course, amplified, my lord, in, my lord, the portion I was trying to show to your lordship, 397, left-hand column, paragraph 2. The first point argued in favor of the appeal is that the respondents were stopped from contending that the civil court had no jurisdiction. My attention has been called to certain rulings of so and so, in which it is laid down that when a party objects to the jurisdiction of one court and procures an adjudication in his favor on that point, and the plaint is thereupon filed in another court, he is stopped from putting forward a contrary view of the question of jurisdiction to one already taken. It seems to me that there could be no question of estoppel in this case at all. It will be obvious from the consideration of section 115 of the Evidence Act that estoppel contains not putting forward a particular view of law, but in making a particular representation on a point of fact. It is only when there has been one representation on a question of fact that a party is stopped from putting forward a contrary representation on the same question of fact. And that has quite clearly not been done in the present case. All that was done, all that was asserted at the trial before the deputy collector was that the recital of the plaint itself, the suit would not lie in that court. In other words, any representation which was made to the court was made by the defendant but not by the plaintiff, and it is impossible to argue that whatever point of law the defendant might have put forward can be prevented or put forward for the representation filed in civil court. There can be no doubt, therefore, that the plea of estoppel must fail. So, my lord, your lordship, my lord, sees, my lord, that, my lord, the first decision I gave your lordship, my lord, is, my lord, on the fact, my lord, that my lord, a point of law, my lord, is required to be pleaded only, my lord, if that is, my lord, based on a factual aspect, and that factual aspect has to be proved. Second, my lord, is on the point, my lord, that, my lord, points of law and points of jurisdiction are not, my lord, hit, my lord, by the principles of estoppel. And, my lord, lastly, my lord, permit me to hand up to your lordships, my lord, a decision of our court. Of course, my lord, coordinate bench of your lordships. My lord, this is 2013, volume 4, CHN, 333. Kindly, my lord, have paragraph 17. Oh, I'm sorry, my lord. I'm sorry, my lord. This was from a different, my lord, citation. Kindly have the last page, my lord, of this judgment. And, my lord, from the second paragraph thereof, at the last page. It is true, your lordship have it, my lord, last page. It is true that a point of law can be agitated at any point of time. But if that point of law is based on some factual aspect, then such factual aspects are required to be specifically pleaded in the pleadings. So, my lord, both limbs, my lord, of this, my lord, short sentence, my lord, are important. It is true that a point of law can be agitated at any point of time. Then, my lord, is the principle, but if it is based on facts, you have to argue the facts. So, my lord, in reply to, my lord, my lord, I'll just deal, my lord, with, my lord, the one decision, my lord, on, my lord, on, my lord, the necessity, my lord, for pleadings, my lord. I'll just deal with that, my lord. My learned friends, my lord, relied upon, my lord, case reported in 2024 SCC Online, Supreme Court 3776. And I think, my lord, he relied on paragraphs 31, 34, 35.
To 37 all along.
Or 31 to 37, very well, my lord. My lord, 31, my lord, kindly see, my lord, this is whether reliefs can be granted in the absence of requisite pleadings. Kindly see, my lord, the necessity for appropriate pleadings in a writ petition cannot be overemphasized. particularly when such pleadings are mainly decided on affidavit of evidence and not on witness action. My lord, I am not, my lord, trying to assert any question of law. This any question of fact. This judgment, my lord, kindly take it, my lord. This is, my lord, completely to determine, my lord, a factual aspect. When a doubt, without a doubt, a court cannot, in the absence of requisite pleadings, grant relief claimed by a party. We first propose to notice two decisions which arose out of pure civil proceedings, and then decisions arising out of writ proceedings. In Pandit Shambhunath Tiku, no doubt the finding recorded by the learned trial judge that 2 rooms of a dharamshala had been granted, the factual aspect of the matter. So, my lord, in my very respectful submission, my lord, this judgment has zero application. My lord, paragraphs 1 to paragraph 37, my lord, will, my lord, show to your lordship ex facie that, my lord, this was completely a factual aspect of the matter, my lord, of which, my lord, notice was being required, that court take notice, without, my lord, a corresponding pleading in that regard. I have no quarrel with this proposition at all. That has to be the law. My lord, kindly just also have paragraph 37. Based on the aforesaid authorities, we hold that while deciding a writ petition based on affidavits, the writ court's inquiry ought to be restricted to the cases pleaded by the party and the evidence that they have placed on record as a part of the writ petition or the counter/reply affidavit, as the case may be. Findings of the court have to be based on pleadings and evidence produced by the parties. It is well impermissible for the writ court to conjecture and surmise and make out a third case not pleaded by the parties based on argument. These are only factual metrics, my lord. They have nothing to do with, my lord, a point of law. ঠিক আছে, ছেড়ে দাও, ছেড়ে দাও।
So you must be over by now?
My lord, this is only one point, but I'll just engage your lordship briefly, my lord, on the other point. So, my lord, so, my lord, this is the first point with regard to, my lord, lack of pleadings. My lord, the second point, my lord, is, my lord, a little more substantial. And that is, my lord, my learned friend says, my lord, that this is a policy decision. My lord, I have, my lord, copiously, my lord, taken your lordship, my lord, to the counter affidavit filed by my learned friend. I will not do that again. In the counter affidavit, my lord, I have invited your lordship's attention to his paragraphs, where he says that, my lord, we made a beautiful corporate bhavan so that all officers of the state connected to corporate department and insolvency department can be in the same, my lord, premises. Thereby, my lord, trying to imply or saying directly that, my lord, the tribunal, which is, my lord, really speaking, my lord, a court under, my lord, 325A and B, my lord, is, my lord, also a part of their infrastructure. So it should go to the same building. My lord, that was the exact case, my lord, which they had made out by themselves in, my lord, the affidavit. Now, my lord, that would, my lord, before I invite your lordship's attention, my lord, to the 2 decisions cited by them and to 2 more decisions, my lord, which I wish to engage your lordship with. My lord, kindly see, my lord, that means that, my lord, any policy decision of, my lord, the government is above, my lord, the reach of the High Court or the Supreme Court or the constitutional courts of the land. For example, my lord, today, if, my lord, in the bypass area, my lord, which are protected Ramsar wetlands, the government decides, my lord, that we will put up a resort. Yes, it's a policy decision. You can't touch it. So, my lord, I think, my lord, it would be a little childish to say that, my lord, policy decisions are above the reach of the courts. That surely cannot be, my lord, the submission of my learned friend. So, my lord, if a policy decision, my lord, is vitiated, my lord, by arbitrariness, if it is whimsical, if it is, my lord, contrary to law, and in this case, my lord, completely, my lord, in the teeth of 2 orders passed by the Supreme Court, then that policy decision, my lord, certainly your lordship will strike it down. So, my lord, no, my lord, action of the administrative action of the government survives only, my lord, on the footing that, my lord, it's a policy decision. Otherwise, my lord, there would be no challenge to any, my lord, decision of the government. Because they'd all say, my lord, this is our policy, we've decided to do it. Now, my lord, in this regard, kindly see, my lord, the 2 cases, my lord, that, my lord, have been relied upon by my friends. My lord, before I take your lordship to, my lord, 2 cases that I want to cite. my lord, the first case, my lord, that they relied upon, my lord, the first case, my lord, that they relied upon, my lord, is 2003 Volume 4 SCC 289, Federation of Railway Officers Association versus Union of India. My lord, this was a case, my lord, where, my lord, new zones, my lord, were to be formed by the railway. New zones. My lord, new zones, my lord, in connection with their business activity for promotion and growth of their business. Now, my lord, this is, my lord, a case where, my lord, the courts have held that, my lord, before, my lord, recommending that a new zone will be put up, they, my lord, set up committees. The committees went into it. And the committees found that these, my lord, the setting up of these new zones, my lord, were required. The committee themselves recommended it. So, my lord, this was a decision which was preceded, my lord, with the setting up of a, my lord, specialized committee which went into the whole matter and gave the government a finding on this. Number one. Number two, my lord, is that, my lord, the separation of one zone into, my lord, various zones and things like that, my lord, did not, my lord, in any manner whatsoever, my lord, offend any existing judgment or, my lord, any existing, my lord, fundamental right of a citizen. And therefore, my lord, the courts held, my lord, that if it doesn't affect or obstruct your fundamental rights, then how can you interfere with, my lord, the decision of the government, my lord, where to have this head office and where to have this? Here also, my lord, if, my lord, perhaps, my lord, these two decisions of the Supreme Court would not have been there, then perhaps, my lord, my friend could have had an arguable case. That is my decision, whether I want to have the corporate bhavan in the High Court premises or I want to have it in Timbuktu is my choice. But, my lord, over here, my lord, this question of, my lord, being, my lord, and, my lord, involving the stakeholders, taking their decisions, nothing done. My lord, kindly recall, my lord, their affidavit is only on the point that all our departments can be in the same premises. Thereby, my lord, treating the court as a part of their department. If the court becomes a part of, my lord, the government department, so, my lord, your lordships exercising writ jurisdiction, they would, my lord, say perhaps in the same breath that, my lord, your lordships are also part of the government. So, my lord, if your lordship, my lord, kindly has this particular judgment, which has been cited by my learned friends, my lord, from, my lord, page 9, or rather, my lord, kindly take, my lord, paragraph 8. Paragraph 8 of this judgment, my lord, at page 298. Paragraph 8, my lord. This court held that court is not the forum in which these conflicting claims may be debated. That whether there is a genuine need for banking facility in the rural area, whether certain classes of community are deprived of the benefit of the resources of the banking industry, whether the administration of the government of the commercial banking activity sector will not prove beneficial in the community and will lead to rigidity in the administration, whether the government administration will eschew the profit motive, and even if it be eschewed, there will accrue substantial benefit to the public, whether an undue accent on banking as a means of social regeneration, especially in the backward areas, is a doctrine approach to our constitution, and whether the policy followed by the government in office or in the policy propounded by the opponents may reasonably attain national objectives are matters which have little relevance in determining the legality or the measures, and it again for the constitution for this court to consider the relative merits of different politics of the theories of economic policies. Then, my lord, paragraph 12, in examining question of this nature, whether a policy is evolved by the government, judicial review thereof is limited when policy according to which purpose for which the discretion is to be exercised is clearly expressed in the statute. It cannot be said to be of an unrestricted discretion. My lord, kindly see. Clearly, policy is clearly disclosed in the statute. It cannot be said to be an unrestricted discretion on matters affecting policy and requiring technical expertise. The court would leave the matter for decision of those who are qualified to address the issues. My lord, here, my lord, there is no such thing. My lord, here, my lord, there is no technical issue. My lord, it is a clear-cut mandate of the Supreme Court that, look here, tribunals, when constituted, cannot take any benefit either in the form of infrastructure or in the form of any other assistance from the parent ministry. And it cannot be set up by the parent ministry. It has to be set up by the Ministry of Law and Justice. Here, my lord, the notifications by the Ministry of Corporate Affairs. So, my lord, today, if, my lord, the Ministry of Corporate Affairs, my lord, and my lord, I'll tell you, lordship, my lord, it has happened in a few decisions. The RBI has taken the decision, my lord. There's no law. RBI has taken a decision, my lord, that one or two companies, my lord, they're not carrying on business properly. So, my lord, the board must be superseded and an administrator must be appointed. Very well, my lord, the RBI has these plenary powers, my lord, under the Banking Regulation Act. But, my lord, what it was followed up with, my lord, is, my lord, that, my lord, the very fact that, my lord, an administrator had been appointed at the behest, my lord, of, my lord, the central government over a particular company was taken to be, my lord, a sign of insolvency of the company, and the company was driven into insolvency. So, my lord, I am not, my lord, trying to, my lord, amplify any particular case before your lordship. I am just saying, my lord, that the, my lord, pleadings made by my learned friends, they themselves say this is our department. So, my lord, this particular decision that has been relied upon by my friends, my lord, your lordship will see that, my lord, when, my lord, there is a clear-cut policy decision based on clear evaluation by experts, then perhaps it is justified. But even then, my lord, this is not a case where, my lord, any court of law, my lord, had given a pronouncement to the contrary with regard to this policy decision. So, my lord, if my learned friends, my lord, have to rely upon this judgment, they have to persuade your lordship that, my lord, irrespective of the fact that there are two my lord, Supreme Court decisions directly on the point, even then, my lord, this judgment, my lord, would enable them to implement a policy decision which is in the teeth of those judgments. The next judgment, my lord, cited by my learned friends is, my lord, a Gujarat High Court judgment. It is unreported, and, my lord, it is a judgment, my lord, of, my lord, the Railway Claims Tribunal. It is a judgment of the High Court of Gujarat on the basis of, my lord, Railway Tribunal claim. It is, my lord, Railway Claims Tribunal's Advocate versus Union of India. Here, my lord, the Railway Claims Tribunal was shifted to a distance of 6 kilometers, which was being objected to. Now, my lord, I'll show to your lordship, my lord, why, my lord, with the deepest of respect, I say, my lord, that this judgment is pari incudium. My lord, in this judgment, at, my lord, page 10, paragraph 23, my lord, your lordships will find page 10, paragraph 23. Perhaps, my lord, in that regard, my lord, this judgment supports me. I'm sorry, my lord, this would be the PDF page. Photo page,
Page 20, niche আছে, sir. You are relying on paragraph 23, right?
Paragraph 23.
It is
It will be page
my
10.
lord, the pagination is at the
Yeah, at the bottom. I've
It would
seen
be
that.
page 10, my lord.
No, 20, sir. It's
20.
no, 8.
Paragraph 23 is regarding another case, R. Gandhi?
Yes, my lord.
Yes.
Now, my lord, R. Gandhi is the case, my lord, which forms the sheet anchor of our submission.
Hmm.
This is the case, my lord, where the Supreme Court, my lord, said, kindly see, my lord, this is quoted. In the case of R. Gandhi, President of Madras Bar Association, Supra, the Honorable Supreme Court observed and held in paragraph 120 as under. We may tabulate the corrections required to set right so and so. Then, my lord, kindly see Roman 12. The administrative support, this is, my lord, exactly what I pointed out. The administrative support for all tribunals should be from the Ministry of Law and Justice. Neither the tribunals nor their members shall seek to be provided with facilities from the respective sponsoring or parent ministries or the department. Clear cut, my lord. Absolutely no, my lord, ambiguity. Now, my lord, this judgment, my lord, of Madras Association, Madras Bar Association, is, my lord, dated 11th May 2010. Now, my lord, it is noticed here. The express, my lord, bar is noticed here. But, my lord, it is not discussed further.
Discussed further.
My lord, I'll show to your lordship how it is discussed, my lord. On the contrary, my lord, if your lordship, my lord, now has, my lord, paragraph 25, my lord, these are, my lord, two decisions, my lord, that have been relied upon. The Honorable Supreme Court in the case of MP Gangadharan versus State of Kerala, my lord, held as follows. So, my lord, kindly, my lord, before going further, my lord, kindly make a note. This is, my lord, a case reported, my lord, in 2006. Madras Bar Association is 2010. So, this is before Madras Bar Association. This is before Madras Bar Association. In spite of that, my lord, the Gujarat High Court, my lord, relies on this. Then, my lord, kindly, my lord, have, my lord, paragraph 26. And this is the principal decision on which, my lord, the Gujarat High Court relies. This is the decision, my lord, of Kannadapada Sanghatan Nagela Okotu Supra. This is, my lord, the decision that has been relied upon. This decision, my lord, is, my lord, of 2002. This is also before Madras Bar Association. And, my lord, Madras Bar Association, my lord, kindly make a note, is of 5 judges. So, my lord, the Gujarat High Court, my lord, with the utmost of respect, relies upon 2 decisions quoted respectively, my lord, in paragraphs 25 and 26. The first decision, my lord, is of 2006. The second decision, my lord, is of 2002. Both, my lord, long before Madras Bar Association. And Madras Bar Association is noticed, my lord, but thereafter, my lord, reliance is placed on these 2. Kindly come, my lord, now straight away to paragraph 29. Keeping in mind the aforesaid decisions rendered by the Honorable Supreme Court and different High Courts, if the fact of the present case are carefully examined, it is revealed that while taking the decision of shifting railway tribunals from one court to another, the concerned authorities have considered the facts so and so. So, my lord, no discussion. Considering the above decisions are set down. Considering the above, this is my judgment. So, my lord, there is no discussion, decision, or, my lord, attempt to distinguish, my lord, Madras. And, my lord, with the utmost of respect, my lord, perhaps, my lord, it is not for the Gujarat High Court, my lord, 5 judges of the Supreme Court, my lord, to distinguish, my lord, what is specifically stated over here. And it's quoted in the body of the
opposition that has been filed by the Union of India has been affirmed by whom? And they take responsibility. Whoever has affirmed this has taken responsibility for all the respondents.
On this, I have a small submission to make. My lord, your lordship will find, my lord, that there are 3 respondents in the writ petition. My lord, they are, my lord, the Ministry of Corporate Affairs, the Ministry of Law and Justice, and the Regional Director of the Corporate Affairs. My lord, only one affidavit has come.
In respect of all?
My lord, they say it is in respect of all, but it is affirmed only by the Regional Director, who is R3. He is the joint
R2.
R2. It's affirmed only by R2. Now, my lord, Regional Director, my lord, is himself a party. And, my lord, there is no corresponding, my lord, affidavit or, my lord, letter of authority which is annexed, which shows that the Ministry of Law and Justice or the Ministry of Corporate Affairs has, my lord, empowered or authorized him. So, my lord, one of the points which we are taking, my lord, which I would have indicated at the end, my lord, because I don't want my lord, my learned friend to say, my lord, that is my best point. But I'm also, my lord, saying that, my lord, whoever has taken responsibility for this has, my lord, perhaps, my lord, completely, my lord, is either unaware, my lord, of these 2 decisions, or, my lord, completely, my lord, ignored the same.
Very well.
My lord, there are, I'm sorry, my lord, I'm holding
Any
on.
further?
My lord, I had to show your lordship 2 decisions, my lord. Can I come back after lunch? Just
No,
10
we
minutes
still
more.
have
Oh.
some few more minutes.
Very well, very well. My lord, then I'll finish, my lord. Then I'll finish. চট করে ওই দুটো দাও যেগুলো আমরা দেখাবো হারিয়ে ফেললাম কাগজটাই হারিয়ে ফেললাম দেখা বলছিস sorry,
My lord,
thank you.
my lord, after my lord, the decisions, my lord, by the clock, 2 minutes, my lord. My lord will stop me, my lord. I will start from 1 and I will try to
It
end
will
it
go
with
on
60
never
seconds.
ending.
My lord, 60 seconds, my lord.
2001
I vouch for those 60 seconds, my lord. Just because the 2 decisions, my lord, has come as an element of surprise, I have got my answer to that, my lord. Just, my lord, for my satisfaction.
Now, my lord, kindly have
2 minutes by the clock. 2 minutes. When
the 2, my lord, it okay, দেবে না ধীরেন my lord, may I, my lord, now, my lord, on my lord, whether policy decisions, my lord, to what extent your lordships will notice them or ignore them, and whether, my lord, policy decisions of the government are the holy cow, which cannot be touched. My lord, let us, my lord, test that proposition. My lord, 2001, volume 1, SCC 158. Kindly, my lord, have paragraph 9 at, my lord, page 7. This court had again an occasion to consider the question as to the principle of law to be applied to a case of resignation made to become effective on the expiry of a particular period from a future date as desired by the employee in Punjab National Bank, so and so. It was held therein that resignation being a voluntary act of an employee, he may choose to resign with immediate effect or with a notice of not less than 3 months if the employee agrees to the same, or he may also resign at a future date, so and so. Oh, I'm sorry, my lord, I'm placing the wrong paragraph. I'm so sorry, my lord. Paragraph 9. I'm so sorry, my lord. Paragraph 9, my lord, at page 164. The reliance placed upon the so-called policy decision which obligated the respondent to furnish a certificate to the extent that he was fully aware of the fact that he cannot later seek for cancellation of his application once made for premature retirement, cannot, in our view, be destructive of the right of the respondent in law to withdraw his request for premature retirement before it ever became operative and effective and effected termination of his status and relation with the department. When the legal position is such that when the legal position is that much clear, it would be futile for the appellants to base their rights on some policy decision of the department or a mere certificate of the respondent being aware of a policy position which has no sanctity or basis in law to deny such a right which otherwise inhered in him as available under the law. No such deprivation of a substantive right of a person can be denied except on the basis of any statutory provision or rule or regulation. My lord, that is exactly, my lord, my case. My lord, my lord, the right, my lord, comes, my lord, under, my lord, 2 orders of the Supreme Court. And you can't take that away by saying I've taken a policy decision. It's as simple as that. My lord, just, my lord, one more decision, my lord, that I'll trouble your lordship with. My lord, this is a decision which again, my lord, is of a larger bench. My lord, here, my lord, the state of Karnataka, my lord, my lord, some English-speaking society of the state of Karnataka had, my lord, filed, my lord, a writ petition, in which, my lord, there was an order of the Supreme Court saying, my lord, that a right of a person to choose English as, my lord, first language cannot be taken away. He may choose. Now, my lord, to nullify that decision, the state government came out with a policy decision that, my lord, the local language, the mother tongue has to be the first language. This was in the teeth of, my lord, the existing Supreme Court order. But, my lord, that could not be set aside, my lord, by a same strength judgment, my lord, of the Supreme Court. Referred to larger bench, my lord, has said that no, This is an inalienable right. It has been held already by us. Therefore, the state government cannot, my lord, based on, my lord, a policy decision, say that no, your mother tongue must be your first language. Anybody has the right to choose whatever he wants to choose. Mandarin to be his first language, my lord, then that's his choice. My lord, this is, my lord, এটা প্রথমে কি এটা কি কোনটা দিলে 2013 টা আগে দেখাবে নাকি? So, my lord, first, my lord, kindly have, my lord, the judgment, my lord, of Justice Satyadevam and Justice Gogoi, my lord, reported in 2013-11 SCC 72. Kindly come, my lord, to the very end. Paragraph 45. At page 86. Considering the constitutional importance of these questions, we are of the firm view that all these matters should be heard by a constitution bench. With regard to the above, the following questions are framed. What does the mother tongue mean if it is referred so and so, so and so? But, my lord, the question, my lord, that was kindly give me one moment, my lord. I'm sorry, my lord, kindly have paragraph 44, my lord, placetum G. Placetum E. The primary school years of a child is an important phase in a child's education. Besides, it molds the thinking process and the tutor's communication skills. Thus, primary education lays the groundwork for which future learning and success. Succinctly, the skills and values of primary education skills are no less than the foundational service, so and so. Likewise, the importance of a language cannot be understated. We must recollect the reorganization of states was primarily based on language. Further, the issue involved in the case concerns fundamental rights of not only the present generation but also of generations yet to be born. So, my lord, they frame, my lord, the questions, and then, my lord, in paragraph 46, my lord, it says, my lord, it will go before the constitution bench. Now, my lord, the constitution bench, my lord, considers the issue. My lord, in 2014-9 SCC, page 485. My lord, I'm almost at the end of my. My lord, kindly have the last judgment. My lord, kindly have it, my lord, from my lord, paragraph. ইস্যুটা কি ওখানে? ইস্যুটা বলছে কি ওখানে বলছে? My lord, kindly just have the operative portion, my lord, in paragraph 63. We have extracted Article 350 capital A of the Constitution above, and we have noticed that in this article
No, it doesn't help you. You will go on reading, it doesn't help you. Page
Very well.
paragraph.
My lord, I'll
Judgment I will take back, I won't refer, it's not required. No policy or nothing of that sort you pointed out from here. Anything else?
My lord, these are, my lord, basically my submissions. My lord, with your, if your lordship so permits, my lord, the policy, my lord, only in this judgment. I'll just take half a minute, my lord. My lord, I have not, my lord, read the facts of the judgment. So, my lord, that is why perhaps, my lord, I have been a little unclear in my.
Understand that.
Yes, I have not read out the facts of the judgment here, my lord.
But then the portion that you read out doesn't say anything about the point laid down.
My lord, the point laid down merely was that, my lord, in order to, my lord, nullify the judgment of the Supreme Court, that, my lord,
The
English
state
can be-
cannot come up as a.
They
come
can't
with
come up,
policy.
my lord, with a something, a decision and
Yeah,
say
yeah,
it's a
that's fine.
policy decision. That
I
was
get
struck
it.
down.
I get it.
My lord,
Yes.
these, my lord, are my respectful submissions. And only one further thing, my lord. My lord, your lordships are aware, my lord, that when the matter was being heard at the interim stage, my lord, with regard to, my lord, the enclad formation here also, my lord, there was a just order by Justice Shorkar saying, my lord, they should file a, my lord, report. Now, my lord, in their report, my lord, they have said that, my lord, the constitution of, my lord, another bench of the enclad, my lord, within the jurisdiction, my lord, of your lordship's court is something, my lord, that they have not yet decided. My lord, we had, my lord, also shown your lordship, my lord, Swiss ribbons, which, my lord, categorically said that we are giving you 6 months' time. To that, my learned friend's reply, my lord, has been this, that, my lord, if I didn't do it, why did you not file a contempt? So, my lord, I shall, my lord, restrain myself, my lord, from commenting upon this. My lord, because I have not filed a complaint, it doesn't mean that you as the central government can say that I will not follow the Supreme Court decision. But, my lord, I'll tell you, lordship, my lord, I personally feel that with regard to the formation of NCLAT, my lord, there must be a substantive, my lord, petition before your lordship, my lord. When, so far as that is concerned, my lord, we'll come up with a petition. We have already
is-
filed the petition,
That is
my lord.
separate.
That's
That
a
is
separate issue, my lord.
My lord, I'm going by my stopwatch. 2 minutes. I will not
I
waste my lord.
have the watch in
No, my lord,
front
I'm
of
going by
me.
stopwatch, my lord. My lord, just time. My lord, first of all, my lord, the NCLT registrar has not been made a party.
Hmm.
So, my lord, question of affidavit coming from NCLT registrar does not and cannot arise. That's regard to affidavit in opposition. The
Yes.
person who has, that is one. Now, my lord, coming to, my lord, the Honorable Gujarat High Court's judgment, my lord.
Hmm.
My lord, my learned senior friend had said that the paragraph 23, the judgment of which has been relied upon by my learned senior friend has not been dealt with. It has been dealt with in paragraph 24. Just make a note of that. Paragraph 24, my lord.
Of which judgment?
My lord, Gujarat judgment,
Gujarat,
unreported.
unreported
Because which is
Gujarat
part on the
judgment.
point.
Yes.
Where my lord
23,
20
R. Gandhi.
R. Gandhi lordship will kindly see that then
24.
23, then my lord 20, paragraph 24, which
Yes.
spills to the next next page.
Yes.
My lord will kindly say, in the present case, we have to examine, last but 6 lines.
Mhm.
In the present case, we have to examine whether the decision taken by the respondent authority of shifting the railway claim tribunal from Nemnagar to Ahmedabad to Kalupur railway station, Ahmedabad, is reasonable or not. There it has been, my lord, I am on this point. Here, my lord, what is the prayer? Prayer is it should not be shifted from the vicinity of Calcutta High Court to there. Now, my lord, if MCA, if the point is that MCA should not provide fund, then the NCLT should be stopped. Because till the time it goes under MOL, that is not the case made out. If it shifts there, then also MCA will provide fund, and if it is allowed to
No,
run
that's
here,
not my- that's
my
not
lord
my
will kindly,
argument.
my learned senior friend should, I have got by the clock 2 minutes.
Mhm.
Now, my lord, so MCA, if
But
it
you're
is
arguing something which I have not
Wait,
said.
wait.
my
Yes.
lord, they have you in the petition, my lord, what they have said is that it should not be shifted. That is the only prayer. Now, my lord, if it is allowed on the point of law that MCA should not be allowed to provide the infrastructure, then this NCLT running here should also stop. Is that their prayer? Is that they are vouching for? Then the point of law comes to their rescue. They are wanting to have their cake and eat it too. They want it to run over here under MCS infrastructure, but not at Rajarhat. One, prayer B, my lord. Now, my lord, this is the hallmark of their point of law. Hallmark is not that they don't want. Ask them, are they vouching for the cause that NCLT not being run? Till the time it is under MOL, it is not their case.
No, it is not my case.
Then
I'll
are they vouching for that? Then NCLT will stop here. Now, my lord, as far as decisions are concerned, my lord will, I have already, my lord, taken 1 minute, my lord. Now, my lord will kindly come to the decision with regard to Order 6, my lord. The first one they had pointed out, my lord. If my lord kindly comes to the decision of 1988,
Yes.
Supreme Court, my lord. My lord will kindly allow me to read that paragraph which was placed, 543, my lord. 543, 1, 2, 3, 4, 5,
Yes.
6, 6th line, 7th line. After HSIDC.
Yes.
In our opinion, when a point which is ostensibly a point of law is required to be substantiated by fact, the party raising the point in if he is a writ petitioner, must plead and prove such facts by evidence which must appear in the writ petition. This is my case. This is supporting me. Those facts are not there about the decision of the Supreme Court and MOL and MCA differences. The same thing goes with, my lord, with decision of 2013 by the Honorable Coordinate Bench, which again passed by my Lord Justice Torun Kumar Gupta, as his lordship then was. The penultimate paragraph, or rather the third last paragraph, says, it is true that a point of law can be agitated at any point of time, but if the point of law is based on some factual aspect, then such factual aspects are required to be specifically pleaded in the pleading, which is in consonance with my Lord Justice Dipankar Datta's judgment, which I had cited of 2024. Now, my lord, last but not the least, the points which we had taken was not only that it will house all the corporates, it was lack of infrastructure as far as this building is concerned. This building being a heritage property and a licensee property, and where we have invested huge amount of money. So, my lord, that is, my lord, I have, by the clock, my lord, I have taken less than 2 minutes.
But only one thing. No, if you.
No, I apologize.
What is sauce for the
I apologize.
sauce for the gander also.
I apologize.
My lord, one or two startling things, my lord, that my learned friend says. He says, my lord, if the NCLT is here under the aegis of the Ministry of Corporate Affairs, why are you not objecting to it? For the simple reason that only the NCLT is here. The ROC, the RD, the OL, the, my lord, other departments of the Ministry of Corporate Affairs are not housed here.
Very well.
So that
Hearing concluded, CV.
I'm grateful, my lord, for giving me those 2 minutes.
Yes, yes.
No.
Will it be required?
That's entirely, but
I don't think it will be required.
if your lordship so wants, my lord, within, my lord, by Monday.
No, no,
we can-
no.
Very well. Very well.
Achha,
আমাদেরটা হয়ে গেছে।
আচ্ছা। ঠিক আছে না? Call.
Grateful, my lord. Deeply amused.
My lord's gift.
For the petition, your lordship.
Did anything transpire?
My lord, they have filed one supplementary affidavit yesterday. I received it, but there is no problem that I received yesterday. And I have interacted with my lord, the ADM. Now, my lord, the whole thing is that as per Rule 40 of the, my lord, the arms rules, my lord, as per Rule 40, first of all, may I tell, I would not take more than 10 minutes time, my lord.
10 minutes.
My lord,
You are already in recess.
that is true. Then, my lord, can I take it? My lord,
2
I do
o'clock?
not want to.
You want it to be
2 o'clock, but after 10 minutes. One contempt matter is item number 3, code number 13. Immediately after that would be over, I shall come here. It will take some 10 minutes.
all right.
Okay.